Who's the attorney on? Is that you, Mr. Abbott?
Yes, Your Honor.
All right. If I am asking a lot of questions, it's because I'm covering a lot of dockets. So, Mr. Carlwright, we got to get used to you being on the assistant prosecutor side.
We all do.
Yeah. So we're on the record in docket 23-01525. That is people of the state of Michigan versus Adele. Kajazovic. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Dale Culture on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Kajazovic.
Yes, sir.
I apologize for mispronouncing his name.
And again, sir, we need a better pronunciation from you, but you are Adele Kajazovic.
Good morning, Your Honor. Yes, my name is Adele Kaitazovic.
Kaitazovic. Thank you, sir. This is the time set for a probable cause conference in the matter. Mr. Callwriter, how are we proceeding?
It's my understanding defense would like to leave the time for next available date.
All right. So I have, as a part of this is a Judge Simmons file, and I have that at this point in time, the judge is requesting that she's not going to be present next week, and so she's requesting that's good cause to waive the 21-day timeline on the probable cause conferences. Mr. Abbott, are you aware of that?
I think I received an email to that effect, Your Honor.
All right, and so what is your response to that?
Well, I'm not in a position to waive my client's 21-day rule, but I do understand if the judge is not here.
Right. Well, I'm placed in a position. We have 3 other judges who could hear the prelim. All right. I think. I mean, I'm not sure what the vacation schedules are for next week. But what I'll do is, of course, you can't waive your client's timeline. I don't know if the judge's absence is a reason for good cause, because since we have other judges who could cover the prelim. So I'll leave the prelim on as requested, and then we'll see who else is available to cover the prelim.
Okay, thank you, Your Honor. And Mr. Callwriter has transmitted an offer to me this morning, which I will communicate to my client. We'll review that, and if anything changes in our attitude towards holding the hearing, I'll let you know.
So this is set on for prelim next Friday. Is that correct? Friday, June 23rd?
Yes.
All right. And then we'll figure it out from there. But it's hard for me to adjourn the matter when we have other judges who may be able to handle it, and it is your client's 21-day right. So with that understanding, sir, please keep in contact with your attorney, Mr. Abbott, in regards to your preliminary examination. Is set for June 23rd at 8:30 a.m. and it will be in front of It'll be in Judge Simmons' courtroom, but we'll figure out what judge covers it, okay?
Okay.
All right. Anything else for the record, docket 2301-525, Mr. Cutler?
Not from the people. Your
Mr. Abbott?
Not from the defense. Thank you.
All right, thank you. You're all set, sir. Thank you for your appearance today.
Thank you, Your Honor.
Mine, one of mine? Or-
Yes.
Okay. I have a docket for mine.
Yep.
Oh, I do have a docket.
I think it's underneath.
It's just, it's just a bunch of stuff.
There's a lot of them.
No, you're good.
Today was not my best for me. So you were correct. All the other judges are here.
All right, so something, we'll figure that one out.
What happened?
892. 88.
I thought that's what the point of that was.
And 32.
Guys left it out.
All right. All right. So Mr. Brodowitz. Let's grab Mr. Brodowitz and we'll put Miss Mervine on. Who's the defense attorney? Ms. Robinson? All right. So we're going to call the case of Miss Mervine, and is she on Polycom? Okay. So we're on the record in docket 20-01032, 20-0188, and 23-00892. I'll call all three cases for our purposes, and then we'll decide what we're doing on the files. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Erin Robinson, Assistant Public Defender for Ms. Mervine.
All right, and ma'am, you are Alaya Mervine?
Yes,
All right, you can hear me all right, Miss Mervine?
yes,
All right, this is the time set for a probable cause conference on the preliminary examinations that are set for next week, I believe. Mr. Brodowitz, how are we proceeding?
I believe these were set for forensic review, Your Honor.
Oh, are they set for forensic?
Yes.
All right. Do we have anything from the forensic?
I
All right, Mr. Brodowitz, you are correct. This is set for a forensic review. I don't have anything from forensic. Do you?
I do not, and I was unsure who was covering for Mr. Silverthorne as he's still in trial, I believe. So I was communicating with Mr. Goodrich last night, and I believe in my communications with him, he informed me that there's at least no update yet, but I guess I would leave that to the defense to further.
All right, Ms. Robinson, can you shed any light on where we're at here?
Yes, so I think that there was some brief communication between Mr. Silverthorne and the forensics center, but I don't think the official order has come down yet, but I don't expect it to be much longer.
All right, and so has Ms. Mervine received her evaluation or is in the process of?
She's already spoken to the doctor.
All right, so it's just a
Yeah,
report.
it's just a report.
All right.
Part.
So we of course are going to adjourn this for the report. How about what's the time frame are we thinking?
Not very long. I have that it's set for a preliminary exam on the 20th. Is that correct currently?
Yeah, I have it set for. All right, but when's the prelim set for? Is there a prelim set? So we might use that prelim date as a control date.
I don't show this, I don't show anything date on her file, sure.
All right, so we can set it.
Oh, actually, Your Honor, I take that back. So it looks like there is a report that was sent, but it was done in 55th. That found that she is competent, so we can actually just leave it on, that's fine, for exam.
All right, and I don't think we have an exam date, and then we can cover this all at the examination when the court gets the report for 55th.
Yes,
What
and I'll
judge-
have that sent over.
All right.
So
So we can set this out on any of our preliminary examination dates.
that's fine, June 30th. I think that would give us some time to work through.
All right.
Any
So,
thing, then we could just leave it to June.
and we don't know Mr. Silverthorne's schedule, so we'll just set it and then we'll wait to hear from your office, okay? Because I know you're covering today.
Yeah.
So, all right, so we're gonna set this for preliminary examination on the 3 current files.
June 30th.
So on file 20-1032, we'll set for prelim on June 30th at 9. All right. And I'll indicate that we are awaiting the finished report to come from 55th via the public defender's office. That's on docket 20-1032. And then on docket 20-0188, we will set it again for that same day, set for prelim. Set for prelim on June 30th at 8:30. And I'll leave the same note in this file, awaiting forensic report from 55th via PD. That's on 20-01888. And then on 23-00892, we'll leave on for prelim.
Those are all misdemeanors, or those last 2 files are
Those
misdemeanors,
last
but
two-
I'm fine, we can just.
Let's
leave
just
that
put them
for
all
pre-trial.
on that date.
Yeah.
Okay. 30. 1, 2, 3 at 8:30. All right,
Just for clarification, Your Honor, the 2 pre-trials are set at 8:30 and the prelim is at 9, or are they all going to
I
be?
just,
we just set them all together at 8:30.
Okay.
I said.
Yeah.
it probably.
Yeah.
I'll probably have to-
We figure these will all be handled together anyway, so. All right, so so for the record, the first file is reset for prelim on 20-01032. The second file, 20-01888 and 00892, the third file are both misdemeanors, and they're set along in companion with the first file. So June 30th being the PCC prelim date, there's also a ticket to go along with that. Mr. Brodowitz, anything else on docket 20-01032 or the accompanying misdemeanors?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. Mervine, your report's done. The court's awaiting it from the 55th District Court. It'll be advanced through your public defender. Your prelim is set for June 30th at 8:30, and the two misdemeanor trials will also be dealt with at that time. All right, ma'am?
Okay.
All right. I know Mr. Silverthorne is your attorney and Ms. Robinson's is covering. Once he's out of trial, if you have any questions, please contact him, okay?
Thank you.
All right, thank you. That's all for the record in 20-01032 or the accompanying misdemeanors. Yeah.
No.
No. Could you give me a file of them?
On Freeland or on Freeland?
Sure.
This one's on Lawrence.
You can just cross them off or just continue it out, right? Files. James came in and told me just like
He told me Lawrence was.
that. Okay, then I won't do anything with Freeland then. I could have totally misunderstood. Thank you, Nadine.
All right, we have Mr. Hess here. What's next? Okay,
The other person that's in jail with a blank screen, they need their free to leave.
all right, who's that?
Lawrence.
Lawrence?
Lawrence docket.
Okay. So, oh, she's, Miss Lawrence, you're free to leave the Zoom courtroom. Thank you for your appearance. I think she's just been told that.
Mr. Lawrence, it's a blank screen.
Oh, is that Ingham County Jail Post? So are you Linnell Lawrence, sir? Are you Linnell Lawrence, sir, from the Ingham County Jail? I don't know if anybody's in there.
Leave on, so.
Hmm?
If they'll leave on, so they can just cross it off the docket.
Okay, just cross it off. That's already done. This is Miss Pavlik here for. Oh, here for John Pavlik. That's a motion, right? Our docket. John Pavlik.
I know we have a couple minutes.
Good morning, Judge.
Ms. Naviat, we'll call your case on John Pavlik, ma'am. We're on the record in docket 12-02493. That's John Pavlik versus Cassandra Pacino. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Margaret Francis on behalf of Plaintiff Attorney of Record, C72322.
All right, thank you, Ms. Francis. You might want to talk closer to your microphone because we're having some trouble picking you up.
Sorry,
And ma'am,
is that a
you
little
are
better?
ma'am, you are Cassandra Pacino?
Yes.
All right. This is the time set I have for an objection to this objection on the matter. This is an objection to garnishments.
Yes.
And you're objecting to your wages being garnished. And Ms. Francis, I'm assuming that you're that you're in response to that objection. Is that correct?
Correct, Your Honor.
All right. So Ms. Pacino, you may proceed on your motion to object. Just a few things for me before we get started here. What is the final amount of the debt owed in this matter? Is that $4,836?
That was the original judgment amount, Your Honor. The current balance is
Miss Francis, we really can't hear you.
I'm
Yeah.
sorry, I have it right on my, let me take my headphones off. Sorry, Judge.
All right. You sounded a little better there.
Is this better, Judge?
Yes, it is better. So what is the debt owed at this point?
Judge, the current balance is $5,594.30. We have received $374.82 from the garnishment so far. I would also note
All
that
right.
we have filed this objection
So what
last
is-
month as well.
So how much is being garnished at this time?
25% of her wages. We've only received $374 so far.
So 25% of your wages. I have an order to the objection that was filed by, I believe, yourself, Ms.
Yes.
Pacino. But I don't have any financial indication. So I guess I would need to know why the garnishment of 25% of your wages is financially unwieldy concerning your $5,594 debt.
Well, I have here, when I went down to the 5th floor, they gave me the Pavlik was the only one garnishing my wages, and I have my statement from CSL stating that this does mean that they were deducting my wages when
I know they were deducting your wages.
before, this was in 2017.
Okay.
When we came in last time, they stated that I had made no payments, but I have proof that my wages were being garnished, and then they were the ones that were garnished at the time.
Ms. Navia, Ms. Francis, have you had the opportunity to speak with Ms. Pacino? She's indicating that that there have been prior payments made on this debt.
She did not attach any of those, Judge, so we have not seen any documents that she's providing.
Ms. Pacino, would you like the opportunity to speak with Ms. Francis in a breakout room concerning some of these matters?
Sure.
All right. Ms. Francis,
If-
would you be amenable to meeting with Ms. Pacino on this? There seem to be paperwork out there that you don't have. Or at least that she's indicating that.
I would be happy to. I just don't know how I'll see the paperwork if has it with her and didn't provide it to us before,
But
Judge.
what I do, if there's paperwork that you haven't seen, is I probably adjourn this objection at least a week for you to see everything, so there'd be a fairness to having information that that Ms. Pacino is claiming that you haven't seen yet. That's my concern, is she's indicating there's paperwork here and she's got it, but you don't have it, or you haven't seen, wants to show me. And maybe if you talk about it and make sure the paperwork's delivered, we can come back here, or there's a resolution that can be reached. So what I'm going to do is I'm going to have, and we're pretty busy today, but I'm going to have Ms. Pacino placed on an iPad, and we'll have, or you can provide a number that she can call, either one, so that you can discuss this matter and so you have an understanding of what paperwork Ms. Pacino has.
Judge, if I may ask to maybe speed it along a little bit, how much is she saying was garnished before?
Right here, this is all the proof that I had, because ADP it no longer is with CSL, so I'm still waiting on ADP to call me back for the rest of them, but $2,268.
$2,268.
Judge, I would say that her objection would still be invalid because that clearly doesn't equal even the underlying judgment amount. And so there would have still been a judgment balance remaining. And then she.
So that'd leave
can
about
still send us
$3,000 on the debt.
And that's fine.
she can
I don't have an objection to paying it, but they're saying that I didn't pay anything. And I know I paid because I have proof right here.
But that's my fears. I'd like to get a number certain at the end of the day. I agree that the debt's not paid off, but a number certain that Ms. Pacino is aware of. So if you're garnishing her wages, she knows exactly the number that it's going to. So what I'm going to do is,
if I could just, I mean, we could definitely look at that paperwork, and if it was towards this particular judgment, then we would, happily credit her account for that. but I don't think that's really
How would
part
they not know
of,
that?
you know, an objection.
Yeah,
That because it doesn't pay it off. So we'd be happy to look at the documentation, but her objection.
I
at this
just want to
point
get a
would be-
number, a number certain that everybody agrees on is the number. Because if we're working from a different number, we have a different argument from each side. If we're working from the same number, then we have the same number, and maybe that garnishment is valid. You know, maybe it's a valid garnishment. I just don't know what the bottom line number is because we have a difference of about $3,000.
And the
If she
yeah,
could
that's-
send the information to us, then we could look at it, and I guess having
All right,
another
so-
date. would be
So
better,
what
Your
I'm
Honor.
gonna do is I'm gonna adjourn this matter so that we can have a number to work from. I'm gonna adjourn this for, I'd say,
2 weeks, Your Honor.
all right, so we'll have Monday, July 3rd at 8:30. And Ms. Francis, what is the easiest way to get you the paperwork so that you see what you have what she has? Do you have a local address in Lansing, or do you have a email address that they could mail it to?
They can email it.
I would feel more comfortable just dropping it off, knowing, because sometimes when you email it, it doesn't attach the correct way, and I would feel.
Okay, you might have to drive for that. There's no
That's
local
fine.
address.
I'm
Okay,
just-
what is the address that you'd like it dropped off at? Copies of it, not the
It would-
originals.
It would be the Grand Rapids address, yes. That's the only
All right, so-
office address we have. Or she can
All
mail
right.
it to us, maybe, quicker mail than snail mail.
Do they have a fax number that I can fax it over to? You have
So,
a fax number?
Do you have a fax number they can use?
There is a fax number, yes. It's
Okay, and what's that number?
616
616
333
333
0708.
0708. So that the copies, both they can be sent to him if you want to write this down.
I don't have a pen. I didn't have one. I just I apologize.
So you can fax this to 616 333 0708. And then I would assume all the other numbers are on the paperwork, Miss Francis. So if there's any follow-up questions, you have the ability to get a hold of Miss Pacino, and she's got the ability to get a hold of you.
Yes, Your Honor. Could I get her email address?
Okay, Miss Pacino, do you have an email address?
Yes, it's Pesino, PESINO, LYNN
LYNN
888
888 at
@gmail.com.
gmail.com.
Thank
So
you,
that is
Judge. If we don't-
PESINOLYNN 888 @gmail.com.
Correct.
If we don't get it by say beginning of next week, we'll email her, and maybe that'll be an easier way.
All right. Then this is
Thank you.
all set for Monday, July at 8:30. Anything else for the record in docket 1202493, Ms. Pacino?
Just one quick question.
Okay.
If I was told they were the only one garnishing my wages, how do they not have proof that their wages? Like, is there a place that I can go to prove that on my end, or? how would I do
Concerning
that?
that they're the only ones that are garnishing your
Yeah,
wages,
that they were the only ones.
I would start with your employer.
Well, then I went there with them, and I'm just waiting on ADP.
Right. I think that would be the main, they know
Okay.
who's garnishing your
Well,
wages.
she said that because it had been so long, they didn't have the bar papers anymore, but
Right.
I didn't know.
Yeah, so we'll await that paperwork. Any questions, Ms. Francis, concerning the Monday, July 3rd date?
No, Your Honor, thank you.
All right, that's all for the record at 1202493. The order on objections to garnishment is taken under advisement until we get a solid number that we know we're working from. Thank you for your appearance today.
Thank you so much. Have a good day.
You too. Mr. Pfeiffer, how are you?
Oh, I'm great.
Okay.
Mr. Yank said he's ready to go on both of his cases. Remington. Last name I can't pronounce.
That last one.
Is that part of the, so who are the co's?
Jessica.
And you've already been.
Okay.
Send email, if you send
I
Chad
did.
an email about it, it's not gonna be on the top, right?
Okay.
Conley,
Conley back,
back,
Jessica, Tarada,
that's the three.
yes.
Okay, Conley,
And I believe
I know you're-
James
her from
and
Council
from Abbott. I
already.
think I saw
But
that.
that was good, and then-
all right.
No, you're sorry, I'm sorry, I already had-
And Mr. Collins' attorney.
I think the only thing I see on here for you are.
Johnson's on Zoom.
I don't know.
Do you want to see if LPD? Do you want to see if LPD?
Mr. Conley's not here.
Mr. Conley's here, but his attorney's not here.
Okay. But see if you can put him on an iPad. You know.
See if jail will just have
Yeah.
an agreement round. So
Yeah.
that he doesn't have.
So we don't have to bring him up if we, you know, since nobody's,
I did
since his
remove it
lawyer's
once,
not
and Judge
here.
let him know, I don't know why. She'd go wanna, is it bottle?
Do I have a number? I'm not sure who the jail surgeon is.
Just email whoever.
Oh, he's been on Zoom now for a while. Lawrence over here? Yeah.
Is the microphone open?
Yeah, let me mute. Did you want to talk?
No, I here.
Yeah, okay.
Mr. Lawrence, the court is leaving your matter set. It's leaving the matter set for exam. We're not going to have a formal hearing today on this, okay?
Okay,
So you're all done.
all right, thank you. Yeah.
Thank you, Mr. Goodrich.
Excuse me.
Then also on the other ICJ where Michigan Black Street, that's Miss.
Yes.
She's free to leave.
So when will be my next court date?
Next week. Next
Exactly.
20.
Yes.
Must be, your exam's 23rd.
Yeah.
Lionel Lawrence, 23rd, 22nd, 26th. I think it's Thursday, sir.
Yeah, it should be Thursday.
Thursday morning.
Yeah, it would be Thursday.
Thursday, the 22nd. All right, Mr. Lawrence, you're all set. Thank you.
Thank
Are
you.
we ready?
Wait, hold on. And then who is the one from the other Ingham jail that I needed
The
to?
screen's black, but that should be Sarah Freeland. She's free to leave.
All right. Ms. Freeland, are you on? Are you available? Are you there? Ms. Freeland? I don't see.
She's on black screen.
Oh, we'll wait on that. All right.
I just didn't want to send this email until we had all, I don't know if everything has to be requested back. I didn't know if Andrew Stevens is ready, and before I asked them to hold up their agenda, I just wanted to make sure we were ready to go on.
Well, I don't know. We're not ready to go on anything right now. So,
I will send the email
yeah,
as soon as you say.
I don't.
I don't know.
Okay. Sir, from the Ingham County Jail, would you identify yourself?
Joseph Tuttle.
Say your name again, sir.
Joseph Tuttle.
Yeah, he's a ward.
All right, Mr. Awuda Coker, we'll call your case. You're joining us by Zoom.
Yes.
All right. So we're on the record in docket 21-00731. That is People of the State of Michigan versus Mark Carr. Will the parties please introduce themselves for the record?
Good good morning, Assistant Attorney General Emmanuel Awuda Coker, behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Carr, who's standing to my right.
And sir, you are Mark Carr?
Yes, sir.
All right. This is the time set for a probable cause conference in front of Judge Simmons. I'm stepping in for Judge Simmons on this date. Mr. Awuda Coker, how are we proceeding today?
Your Honors, my understanding that Mr. Carr will be waiving his preliminary exam today.
And is that your understanding, Mr. Goodrich?
Yes, Your Honor.
Is there an offer or anything or negotiations to continue?
There is an offer. It's a long, complicated
Right.
offer, but yes, we've been
Okay.
in exchanged emails.
All right. So my understanding is that there is an offer and negotiations are to continue. Is that correct, Mr. Awuda Coker?
That's accurate, Your Honor.
All right. Mr. Goodrich, may I inquire of your client of his right to preliminary examination and his waiver?
Yes, Your Honor.
All right. Mr. Carr, you understand that you have a right to preliminary examination within 21 days from your date of arraignment. Do you understand that, sir?
Yes, sir.
Okay, and you understand that a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence through the Attorney General that a crime was committed and the identity of the person who committed that crime. Do you understand that, sir? And Mr. Goodrich would be present to cross-examine any witness and contest any charges brought against you in this file. Do you understand that?
Yes, sir.
There's been some negotiations and an offer made. It's my understanding you wish to waive your right to a preliminary examination and have this case continue on to circuit court. Is that correct?
Yes, sir.
Is it your wish to waive your right to a preliminary examination today?
Yes, sir.
All right. Does the Attorney General also waive their right to a prelim, Mr.
Yes,
Awuda
Your Honor.
Coker?
Yes,
All
Your
right.
Honor. Thank you.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made, and I will bind the case over as charged at this time based on the waiver. So, Mr. Carr, please keep in contact with your attorney, Mr. Goodrich. Your next hearing will be in circuit court. Your time in district court is done, and that date will come from circuit court. Okay, sir?
Yes, sir.
All right. I'm going to have the waiver signed. Anything else for the record in docket? Let me find that docket number. In docket 21-00731, Mr. Goodrich.
No, Your Honor.
Mr. Awuda Coker, anything else?
Nothing further, Your Honor. Thank you.
All right. We'll await Mr. Carr and Mr. Goodrich to sign the document.
I don't know if I'm next or not.
Yeah, let's see who's next, then if it's not you, I can just real quick.
I just walk up and get straight here.
Yeah, usually like,
So they're gonna talk to a lawyer first, cause like,
if your lawyer shows up, then yes, if you're.
All right. I'll also sign the document.
all right.
All right. That's all for the record in 21-00731. Mr. Awuda Coker, thank you for your appearance. You're all set on this file, Mr. Carr.
Thank you.
All right, thank you.
And then did you have another case you wanted
I
to
have
call?
two that are Jeff Brodowitz cases.
All right. Let's get
Stevens
Ms.
wants to step in and do a couple quick waivers.
I can do a couple quick waivers.
Okay.
All right. What's the next one, Mr. Goodrich?
Certainly within my wheelhouse.
Philip Owens.
Philip Owens is on my docket, correct?
No.
All right, let's do that one over just in case. Philip Owens. And Owens. All right, so we're on the record in docket 23-01672. That is People of the State of Michigan versus Philip Owens. Will Will the parties please introduce themselves for the record?
Morning, Your Honor. Andrew Stevens on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Owens, who's standing to my right today.
And sir, you are Philip Owens? All right, this is the time set for a preliminary examination today. It's my understanding this is a waiver, Mr. Stevens.
That is what Mr. Goodrich has also informed me. So with that, I'll defer to Mr. Goodrich.
All right, Mr. Goodrich.
Yes, Your Honor, he is waiving his preliminary exam today and negotiations will continue in circuit court.
All right, Mr. Goodrich, may I inquire of your client of his waiver?
Yes, Your Honor.
Okay. So, Mr. Owens, you understand you have a right to a preliminary examination within 21 days of your date of arraignment.
Yes.
And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime was committed in this file and the identity of the person who committed the crime. Do you understand that, sir?
Yes.
You, of course, are represented by attorney Mr. Goodrich, and he would be present to cross-examine any witnesses and contest any charges in that hearing. Do you understand that? It's my understanding that on this file, you wish to waive your right to preliminary examination and have this case continue. Negotiations are continuing on this case. Is that your understanding? Is it your intent today is it your wish today to waive your right to preliminary examination?
Yes.
And are the people also waiving their right to preliminary examination?
We are, Your Honor.
All
Thank
right.
you.
I find the preliminary examination being, the waiver of the preliminary examination being knowing, voluntarily, and accurately made. And this case is bound over to circuit court as charged. So your next date, which will come from Mr. Goodrich, keep in contact with Mr. Goodrich, will come from Mr. Goodrich. It'll be in circuit court. Your time in district court is done. Okay, sir? All right. I'm going to have Mr. Goodrich and his client sign the bind over. Mr. Stevens, there might be a place for you to sign on that. I already did.
Thank you.
All right, I'll sign the bind over document. That's all for the record in docket 23-01672. You're all set. Okay, sir?
Take care, sir.
This Quantrell Lake is another
Mr. Lake.
waiver.
Is that a miss? That's one of
Your
ours.
case as well.
All right.
Perfect. Thank you, sir.
All right, so we're on the record in docket 23-01515. That's people of the state of Michigan versus Quantrell Lake. Will the parties please introduce themselves for the record?
Mr. Stevens on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Lake, who's standing to my right.
Sir, you are Quantrell Lake?
Yes.
Okay. This is the time set for preliminary examination. It's my understanding that this is a waiver today, Mr. Stevens.
That's correct, Your Honor.
All right, Mr. Goodrich, you can tell us what we're doing here.
Thank you, Your Honor. Your Honor, Mr. Lake will be waiving his preliminary exam. There's no offer at this time, but negotiations will continue in circuit court.
Thank you, Mr. Goodrich. May I inquire of your client of his waiver of his preliminary examination?
Yes, Your Honor.
Mr. Lake, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment? You understand that, sir?
Yes.
Okay, and a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're represented by Mr. Goodrich from the Public Defender's Office. You would be present to cross-examine any witness or contest any charges brought against you at that hearing. Do you understand that, sir? Okay, it's my understanding that you wish to waive your right to a preliminary examination today with negotiations to continue on this file. Is that correct? All right. So do you wish to waive your right to a preliminary examination today?
Yes, sir.
All right, and the people are also waiving their right to a prelim, Mr. Stevens?
We are, thank you.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. going to bind this case over as charged with negotiations to continue. So any future dates, Mr. Lake, would come from Mr. Goodrich in circuit court. Your time in district court is done. All right, sir?
Yes.
All right. I'll have the parties sign the bind over.
Yeah, we need to more like sensing stuff, ways down the road.
Tuttle.
Yeah. I'll jump on Zoom while I don't know who the other person is though. Two of them.
My guess is,
That's
my guess is.
Judge Ward case.
Yes.
And Mr. Goodrich, did you need to speak with Mr. Tuttle?
Yes.
Okay.
David,
We all set?
Yeah, we are.
Yeah.
So if you join us, we'll put you in a breakout room with them, or if you want to go down and speak with them.
Just call me.
Either or.
Mr. Tuttle, I'm pretty sure is in Mason right now.
Okay, so yeah, that answers that question. All right, Mr. Tuttle, I'm going to put you, when your attorney, Mr. Goodrich joins us, I'm going to place you in a breakout room with them, okay?
Okay.
All right.
Good. You see you? Yeah.
Sir, from the Ingham County Jail what is your, can you identify yourself, sir?
Isaiah Tyler.
Isaiah Tyler. Thank you, Mr. Tyler. Record. All right, Mr. Tyler, we're calling to the record docket 2300. That goes to Mr. Yang, I think. Oh. I do. All right, so we're on the record in docket 2300-849. That's People of the State of Michigan versus Isaiah Tyler. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people. And there is no defense attorney assigned to this case, so there is no defense attorney to put.
All right, and sir, you are Isaiah Taylor. Is Isaiah Tyler? Is that correct?
Yes, sir.
All right, and it's my understanding you're without counsel today. Is that correct?
That is correct, but I should have been assigned an attorney until my attorney was
right.
Yes.
Right. Yeah, I understand that. You don't have a lawyer yet. Is that correct? Is that correct, sir?
Correct.
All right, Mr. Pfeiffer, you want to reiterate what you said off the record?
Absolutely,
concerning?
Your Honor. I spoke with people from the Public Defender's Office who looked up Mr. Tyler and this new case in their system. His screening is currently being processed. I have no doubt that he will be assigned a public defender. I think he already has one for a different case up in the circuit court, but it's just a clerical issue of it taking some time. As a result of that, Your Honor, that is unrepresented by counsel at the PCC. We can't effectually have the PCC. I would ask that the preliminary examination date stay, so it's still in the books, just be treated as a probable cause conference with no witnesses called in.
All right.
By that time, he should have a public defender assigned.
All right, so Mr. Tyler, you're not going to be waiving any rights today. We're going to leave this on for preliminary examination for next week. And in the interim, make sure that you have a lawyer from the Public Defender's Office to represent you. And since you don't have one today, we're going to treat that preliminary examination as a probable cause conference, okay?
Yes, sir.
Do you have any questions of me, Mr. Tyler? We just want to make sure that you have legal representation.
Correct. So what was today?
Today was a probable cause conference, and then next week is a preliminary examination, and you should be represented at both. So, and we understand that this is just it's just an application process that may take some time. Within that week, you should be represented by counsel. They should get discovery. and they should be able to have a true probable cause conference for you next week. So we're just leaving it on for next week with the understanding and hope that you'll be represented by counsel next week.
Okay, and you guys say next week, what, is there a date on that, sir?
Yeah, it's June 22nd at 8 a.m.
Okay, sir.
All right. Anything else for the record in docket 2300849, Mr. Pfeiffer?
Not from the people, Your Honor.
All right, Mr. Tyler, you're all set, and you should be contacted by the Public Defender's Office.
Okay, thank you.
Thank you. That's Mr. Tyler. Mr. Pfeiffer, you have 3 dockets here. You have anything else going on in any of these dockets?
I have McLean, who is in custody, and then we have the Elamine preliminary examination.
All right.
Which I intend to run.
All right. So wait on
Your
that
Honor, I will
one.
be requesting adjournment of that.
All right.
So-
We can talk about that.
All right, I'll let you talk to Mr. Pfeiffer about
Oh,
that.
we've already spoken. I'm
Okay,
objecting
yeah.
to the adjournment.
All right,
But I will be requesting adjournment of that.
and that's on which one?
Elamine,
Elamine.
the 9 o'clock preliminary examination, Your Honor.
Elamine, all right. And is Mr. Elamine here?
Yes, Your Honor.
Okay.
Yeah.
Well, let's go ahead and put that one on the record.
Elamine, right now? Okay.
Yes. Who's that?
Isaiah Tyler.
Oh, yeah. Mr. Tyler, you're all set. You can leave, okay?
Okay.
Or they can come get you, but you're all set.
Excuse me.
Yeah.
Okay. All right, I've got to tell them that another case has been resolved. Hey, Sage. Tuttle is going to we're just gonna leave that set, like you said, and then I'm gonna meet with him next week and we'll decide if we want to take that offer or not. I think he probably will.
Mr. Stevens, on your case, what, yeah, what do you, this is Johnson. 22-03512. That is people of the state of Michigan versus Amber Marie Arnett. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Jacob Sarris, fourth assistant public defender here on behalf of Ms. Arnett. She's standing at my right.
And ma'am, you are Amber Marie Arnett? All right, this is the time set for a probable cause conference in front of Judge Simmons. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding this morning that just the defense is waiting on some discovery items and are seeking to waive the 21-day timeline and have the preliminary examination reset.
And Mr. Sartz, is that your understanding? Your client wishes to waive their right to a prelim within 21 days for discovery, in order for you to get discovery to zealously advocate for your client?
That's correct, Your Honor.
All right.
We're requesting an adjournment this morning.
All right. May I inquire of your client of their waiver of their 21-day rule?
Yes, Your Honor.
So, Ms. Arnett, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. And you are represented by Attorney Jacob Sarks, and he would be present to contest any charges, cross-examine any witnesses brought up by the state against you. Do you understand that? Yes. It's my understanding you wish to waive your right to a preliminary examination within the 21-day period. You would not be waiving your right to a preliminary examination in total, just within that time frame, so that Mr. Sarts can get further discovery in order to zealously advocate for you.
Yes, sir.
Is it your wish to waive your right to a prelim within 21 days? Yes. Ms. Housefield, do you waive your right to a prelim within 21 days?
Yes, Your Honor. Thank you.
All right. With that understanding, the waiver of the 21-day rule is found to be knowing, voluntarily, and accurately made, and we will reset this prelim on Judge Simmons' docket for, let's see what dates are available.
July 13th at 10:30.
July 13th at 10:30. Does that work with you for your schedule, Ms. Housefield?
I may be in trial, Your Honor, but certainly there's someone that could cover it for me.
All right. So we'll set it for July 13th at 10:30 in front of Judge Simmons. Anything else for the record in docket 22-03512, Ms. Housefield?
No, thank you, Your Honor.
Mr. Sarts?
Nothing further, Your Honor.
All right, thank you. Ms. Arnett, you're all set. Thank you for your turn today.
You got it.
I'll see if I can find Mr.
All
Levine, Your
right,
Honor. Thank you.
okay. So we do have the Ingham County Jail. So let's see who we've got.
Yeah, you go give him a call.
So let me.
Yeah, Mr. Alameen is not in the building.
All right.
I don't know where Mr. Goodrich went.
Starts is gonna go try and call him and get him back here.
Tuttle's gone, so I don't know. I don't know what they call that.
Let's see, in our co-defendant case, we have Mr. Hess, you have Mr. Beck?
Yes, I'm representing Mr. Beck, Your Honor.
Okay. And Mr. Johnson is here for Mr. Conley.
Yes, sir, Your Honor.
And- all right, thank you. Just making sure I've got all the players. There's a lot of moving parts here. And then Mr. Yang, you're here on Miss, and you said it eloquently.
Parwasicha.
Pradawaticha.
Yes.
Okay. And that's Mr. Yang. So those are the three, right? Conley, Pradawach, and Beck.
Can we go get Mr. Beck?
Yeah. So let's have Mr. Beck brought up.
Oh,
Did you make sure he's in he might be on the. So, Mr. Johnson, I know you're on a time frame, but we're going to call that case next once we get all the players, okay?
Yes, sir, Your Honor, and I'm willing to waive my client's presence if the court will accept the waiver.
But your client is Mr. Conley, and we're bringing him up right now.
He's being put on.
Yes, sir. Oh, he's being put on Zoom right now, so you just join us by Zoom.
They do everybody like this? I just don't understand why.
They can hear you talk.
Oh, I'm sorry.
Yeah, we're right on the.
Yes. I would have lost it before, definitely. All right, thank you, Mr. Yang. All right, so we're on the record in this 3 co-defendant case. We're on the record in docket 23-01607, 23-01661, 23-01236, 23-01606, and 23-01658. So Mr. Beck's attorney, for the record.
Yes, Edward Hess is hearing on that. Mr. Beck has been brought from the county jail. He's tonight.
And sir, you are Jonathan Beck? Yes. All right. And then Mr. Conley, your attorney for the record.
Good morning, man. Please, this honorable court, Kareem Johnson, P number 71988, appearing on behalf of Mr. Conley, who's present on Zoom.
And sir, you are Aaron Conley, is that correct?
Yes, sir.
Okay, and you can hear me all right, Mr. Conley?
Yes, sir.
All right, thank you. And then I'm gonna call you Jessica P for now, okay? Mr. Yang, your appearance and your client.
Thank you. Good morning, Your Honor. Joseph Yang on behalf of Ms. Jessica Padua Sichai. Moving forward for the record, it will be Jessica P.
Okay.
Just so the record is clear, she is president to my right.
And ma'am, you are Jessica, and I'll try it, Prawa Ritsai. Close enough?
Yes, sir.
All right, or Jessica P for now. All right, thank you, ma'am. And Mr. Stevens, your appearance for the record.
Mr. Stevens, on behalf of the people.
All right, this is the time set for preliminary examination. Mr. Stevens, how are we proceeding today? I am in possession and have read your motion. How would you like to proceed?
Thank you, Your Honor. Well, certainly we'll start with the motion because I think that ultimately addresses what may or may not unfold thereafter. As the court indicated a moment ago, you are in receipt of the people's motion to adjourn the scheduled preliminary examinations and consolidate all of these cases with the other pending case. That would be, excuse me, that would be to consolidate with charged co-defendant Julia Hartwig, which is in docket number 23-01235 FY. I would note for the record, I have had the opportunity to speak with Mr. Yang, who is to my right, Mr. Hess, who's to my left. Both of them are in receipt of my motion and have reviewed it. And then I know Mr. Johnson is on Zoom. I am almost as confident, if not more confident, that he has also reviewed the motion. I was able to exchange a few emails with his staff yesterday regarding the motion. So, and I believe he indicated to your staff as well that he was asking about timing, specifically referencing the people's motion. To sort of be brief, Judge, because I know you've reviewed it, it is the motion extensively and seemingly exhaustively outlines the various timelines we have with these. What we have 3 defendants here today, but it also includes a 4th defendant that I referenced a moment ago, Julia Hartwig. They are all on different timelines because of when they were arraigned on their respective charges. It is the people's request pursuant to the court rule that I cited that all of these matters be consolidated for one single and joint preliminary examination. As I referenced in my motion, effectively starting from paragraph 18 through the conclusion of the motion, when you evaluate these respective cases, when you look at the overall landscape of what would ultimately transpire at the preliminary examination, and you contrast that with the court rules regarding joinder and severance, which is what I've referenced specifically in paragraph 21 and 20, just 21, which is MCR 6.120. The factors regarding joinder direct this court and certainly weigh in favor of joining each of these defendants for a joint preliminary examination, specifically as it relates to the first, or what I'm referring to as the underlying case. It's the same conduct or transaction with defendants Aaron Conley and Julia Hartwig. And from that same conduct or transaction, there are a series of connected acts that incorporate both defendant Aaron Conley, but co-defendants Jessica P. and Jonathan Beck. As I referenced in my motion, it would an examination for all of these cases would require the exact same witnesses, the exact same evidence. And because of the sort of parallel yet not corresponding timeline, theoretically, the people would have to run this preliminary examination before this court on three separate occasions. And so again, we're referring to and relying on MCR 6.11A. that people are requesting a joint and consolidated preliminary examination. I would note for the record, as I detailed in my motion, the people have already entered into a stipulation and agreement to adjourn as reference to Jessica P. with Mr. Yang, given his late appointment. And this was something that I know I personally addressed with the court last week. I believe Mr. Abbott also addressed it with the court at the pre-exam conference. I addressed it during the matter in which Mr. Johnson and I appeared with Mr. Conley and indicated to the court that I foresaw that this might be an issue. The timing of this motion and some of these details was from the people's perspective was contingent on receiving information from the Office of the Public Defender. Again, I referenced, as it relates to Mr. Yang, I referenced some of that timing, that his appointment and acceptance of that appointment and confirmation of that appointment only happened at best within the last 48 hours. And so I know, in speaking with Mr. Yang, and I'm certain and confident he'll confirm this, he has received absolutely no discovery. So when you layer in that aspect, it certainly seems that a joint and consolidated preliminary examination is appropriate. As I referenced in my motion, I have suggested a new date or proposed date of June 29, 2023. I hope it is clear as to why I suggested that date, because that is the examination date for the last defendant to this party, which is Julia Hartwig. That is the scheduled date for her preliminary examination. And so that seems to be most appropriate. That is what I have requested. I understand various schedules, court schedules. If that needs to be modified, I will defer to the court and the parties. Unless the court has any specific questions for me, I don't feel it's necessary. I have to go into every detail I covered in the motion. But if the court has any questions, I'd be happy to address them.
All right, thank you. The court understands the motion and the motion and the request made. Mr. Hess, anything in response to the motion on behalf of Mr. Beck?
Yes, the motion, of course, is understandable, and it's to the ends of justice that only one preliminary examination be conducted, because we don't want testimony that's inconsistent, even by mistake, between the different hearings. So I'm absolutely fine with Mr. Stevens' proposals. I do have a scheduling issue. I am completely unavailable on the 29th specifically. So if the court has any other date, I would request that. Of course, I can always find coverage, but I would rather, and I hope Mr. Beck would rather have me here representing him since I am his attorney of record. And I do have another request relating to Mr. Beck's other file. I'll just preview that for the court. I'm asking that whatever date the court chooses for these consolidated preliminary examinations, that Mr. Beck's other preliminary examination also be set for that date, so I can be present for that as well, Mr. Beck.
All right, so yeah, because Mr. Beck has the file 23-01607, and then he also has the pending 1661 file. Is that correct?
Yes.
Okay. Mr. Johnson, in response to the prosecutor's motion and Mr. Conley.
Your Honor, the statute and the court rule regarding having one examination is clear, and I think it's correctly stated in the motion. However, that court rule presumes that will improve judicial efficiency. And in this case, I don't see how it will. And so for that purpose, we are objecting. Specifically, just today, I've been on Zoom for 2 hours regarding a matter that's in which the people are going to be asking for an adjournment. I have a circuit court judge who is still emailing me wondering, what is taking, when I'm going to be there. We now have an attorney who does not have a discovery. I believe that my client is on a parole hold and is not getting any credit for the time that he is in custody. And similar to Mr. Hess, the 29th is not available, is not a good day for me at all. I'm from Jackson County. Our court dates are not consistent. Today is a sentencing day for us. That's why circuit court judges are looking for me. So it will require 4 attorneys in different counties to get on one schedule. And I don't know how the court's going to do that, and I don't even know if I have time to do that today. With my schedule, I understand the people's position. There was nothing in the motion that indicated how hard they were looking for these other defendants who had not been arrested. So we'd ask the court to take that into consideration. But I'd also like to, when the court is ready, address a bond condition for Mr. Conley.
All right, thank you. Mr. Yang, your response to the motion, to the people's motion.
Thank you, Your Honor. For the record, I did receive the motion and did review it. I really have no position for that. As far as the adjournment, I'll be requesting that as well, as we stipulated to already. As far as the consolidation, I'll leave that up to the court. I hold no position as to the preliminary examination. If we get to a trial stage, that's different, but for the record, for the prelim, consolidating those, I hold no position and leave that to the discretion of the court.
All right, thank you. All right, so in regards to, and it's my understanding, Mr. Stevens, there is still a 4th co-defendant who does not have counsel in this matter. Is that correct?
Ms. Hartwig has been arraigned, has been requested counsel, I believe, and this is from the court notes, she was represented at arraignment. That was likely from the public defender's office. And speaking with Mr. Cornish, who is deputy chief at the public defender's office, they will have to conflict out, and they are awaiting acceptance of conflict counsel. That may have resulted, but at the time of writing the motion and filing it yesterday, that had not yet been done. But at the same time, that was at best 24 hours after Ms. Hartwig's arraignment. So that would be an incredibly fast conflict appointment and acceptance.
All right. Well, the court has read I've had the opportunity to read the motion. I've also read the court rule concerning this. And I find that there is good cause to put all, to not sever and not treat this as a separate entity, all the co-defendants involved in this case, pursuant to the motion that was filed 6.110 and the underlying factors in regard to 6.11A. I find that this should be kept together and consolidated. So the preliminary examination is adjourned. We have to wait for Mr. Hartwig to get discovery. We have to wait for Mr. Yang to get discovery. We have 2 attorneys in which that June 29th date is not feasible for whatever reason. But so what I'm gonna be asking is that all the attorneys get together and find a date that works for their schedule and for the court schedule. Several dates that you have that'll work together, you can contact my court officer and we'll find, and because we have some afternoons that we could put this on if we're going to take prelims. So it doesn't have to be a Thursday, Friday, so to speak. It might be a Tuesday afternoon that we can actually put that'll fit everybody's schedule, but we'll be able to take testimony because this is, 4 co-defendants and somewhat unwieldy. So with that understanding, the motion's granted. I'll grant the adjournment in regards to, I think there's a good cause adjournment here, to good cause adjourn. I'm not going to expect anybody to waive any preliminary examination rights within 21 days. This is somewhat unwieldy. There's 4 co-defendants, and one of them is in the process, has just been arraigned. So we have to be cognizant of that co-defendant also. But I will leave it to the lawyer's schedules to come in and try to get a good afternoon so that we will set it for a prelim and expect it to go on that date, or something that happened on that date. So with that understanding, we'll adjourn and wait to hear from the attorneys concerning an afternoon of testimony. So Mr. Hess, anything in regards to that? We're going to look for a different date from June 29th.
No, nothing further. Thank you.
All right. Mr. Johnson, I understand that you're out of county, and so we'll get a date that works for you in the afternoon. You also wanted to be heard on bond in this matter.
Yes.
So I at this time, you can indicate if that your understanding of the court's ruling, that you'll get together and get a date that works for you, and then I can hear you on bond.
Yes, Your Honor, I understand the court's ruling, and I will email all parties concerning which the court date that works. Your Honor, we're not really asking for a bond. We're asking for a lifting of the restrictions. When I was last there, I was able to look in, to what kind of has happened procedurally. And it appears that, Mr. Conley's previous attorney withdrew. The court held a hearing regarding an alleged bond violation in which Mr. Conley was unrepresented and took detrimental action against him, put him in the hold and placed phone restrictions based on a subsequent case in which it is alleged that he's trying to intimidate or interfere with the witness. When I was there last week and the prosecutor made their brief recitation of the facts, I think I told the court, so what? What did he do wrong? And after I've had an opportunity to read the police reports, I now see why the prosecutor didn't state on the record last week one threat that my client is alleged to have made to any witness, because he didn't make any. This investigation, the witness intimidation, seems to stem out of a co-defendant's arrest in Kansas City, and there's no evidence that my client directed anybody to tell any witness to not come to court, to bribe any witness to not come to court, or to threaten any witness to not come to court. There is an accusation that my client was under the impression that one of the complaining witnesses has signed an affidavit indicating that he wasn't involved in any of this, and he was trying to get that affidavit. There's nothing wrong with that, Your Honor. So we'd ask the court at this time to lift those restrictions. And, my client understands that he cannot have any contact with any of the witnesses or co-defendants. He's going to have to rely on my office to do his investigation. But at this point, Your Honor, I don't see the need for him to be in the hole, for him to have any phone restrictions.
Thank you. Mr. Stevens, response.
Thank you, Your Honor. An accurate recitation of last week was I wasn't going to go into the facts because I didn't think it was fair to Mr. Johnson, who had been appointed to the case the night before and had no discovery. And I said explicitly that I wasn't going to try the case or the facts before the court because that put Mr. Johnson at a detriment. It wasn't fair to him and it wasn't fair to his client. Reality is, as Mr. Johnson has talked a bit about the facts, the statute doesn't require threats be made. The statute only requires that there be a showing that an individual impede and interfere with a witness. Oftentimes that comes in the form of threats, but there has been, and even Mr. Johnson referenced, an indication where the complaining witness has been contacted through a series of communications, starting with his client, Mr. Conley, through a connected chain, specifically the co-defendants, in which the complaining witness was confronted with making an affidavit that he wasn't going to appear for court, a quote of no face, no case. And the people anticipate the proofs will establish that this complaining witness felt as though he was being interfered with, impeded, or at times personally threatened regarding his experience of the underlying case because he's a witness. And so it's for those reasons. And because many of those contacts were documented, saved, and provided as discovery through the Ingham County Jail system, both phone call and video conferencing, the people made that motion. It wasn't a bond violation. It was the people's request to maintain the status quo and protect the integrity of the case, and ultimately the protection of the society, specifically the complaining witness. And it's for those reasons we made the initial request. I didn't go into these facts last week, as I outlined a moment ago, but in light of all of that, I would ask that those restrictions remain in place, please. Thank you.
All right, so.
Your Honor, can I say anything, please?
You may.
Mr. Collins, don't say anything. Don't say anything. Anything you say can be used.
I'm sorry, Mr. Conley, let Mr. Johnson speak on your behalf. He is your lawyer. Mr. Johnson, did you want to respond to the argument made by the prosecutor?
Yes, Your Honor. I have seen no evidence that the people have that my client directed anybody to have contact with any witness to prevent that witness from coming to court. The only evidence that I've seen suggests that my client was under the impression that an affidavit had been signed. And at first he was instructing his attorney to go get the affidavit. His attorney withdrew. He was having somebody else get it. At this point, and we don't know what the testimony will be. Testimony may come out and testimony may not come out. But at this point, through the police reports I've seen, the recordings that I've seen that have been documented, there's no evidence that he instructed anybody to tell a witness to not come to court. There's no evidence that he instructed anybody to intimidate a witness to not come to court, or to even ask witnesses if they come to court or not. This whole no face, no case thing, that's common sense. If a complaining witness does not come to court, oftentimes cases are dismissed. But there's no evidence that he told anybody to tell a complaining witness to not come to court. So to have him, and especially if it wasn't even a bond violation, to have him on these restrictions, I think is prejudicial and will suffer irreparable harm if they're not lifted immediately, Your Honor.
Thank you. The court has had the opportunity to hear the arguments made in the case. I agree with the co-counsel. The restrictions as to notification may be seen as prejudicial to his client. However, I don't find them to be unfairly prejudicial concerning the 10-year witness intimidation felony that has been alleged and will be requested for bind over on a probable cause. I'd also notice that this is a habitual fourth offense notice. So with that understanding, I'm going to deny the motion to amend the bond conditions and keep the bond conditions as is. And we will await for a new date for testimony to be taken concerning all of these files in regards to this case. Anything? We're gonna have to email them out. So we've got some dates, so contact, but I want to make sure that everybody's good with the dates because it's simply a little unwieldy process to make sure that four lawyers get in the same courtroom on the same date with the same judge. All right. Anything else for the record in any of these cases? So 23, Mr. Stevens.
I have one thing to address, and Mr. Hess referenced it with his client, Mr. Beck, on the 1661 FY. Since that case, as referenced in my motion, is largely and frankly wholly independent of my motion and the underlying the other co-defendants, I think, at least it'd be my opinion, that the proper course to handle that and would be for Mr. Beck would have to waive his 21 days on that case.
I agree with that.
Because you're not making a finding, and nor did I make a request.
Right.
Now, Mr. Hess already indicated that it was his client's request that 1661 track. And so I'll just indicate to the court, the people, I have no objection to that, and frankly stipulate to that for the purposes of this record.
Thank you, Mr. Stevens. That is true. Mr. Beck, you indicated that docket 2301-661 would follow the pending file in regards to the co-defendant files. The motion was in regard to the co-defendant files. It's my understanding, or is it your wish to proceed in that matter and have this file set with the other files, the other co-defendant files?
Yes, I would like, please, for all the files to track together. I'll just note for the record, Mr. Beck is having some back pain. He just stood up out of respect for the court, but I would ask him for permission for him to sit down.
Absolutely. And does your client intend to waive his right to a prelim within 21 days in order to set this out to be with the other prelims?
Mr. Beck, are you fine with having all the preliminary examinations set on the same date? We don't know how far out yet. You can also demand that we hold the one preliminary examination today. And if the court is able to do that, we can proceed with that one today. So I'm asking for it to be set out. Mr. Beck has indicated he's fine with all the preliminary examinations being set out.
All right. So may I inquire of your client of his 21-day rule?
Yes.
Okay. So Mr. Beck, you have an understanding. You have a right to a preliminary examination within 21 days. Do you understand that, sir? Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the identity of the person who committed the crime and that a crime was committed in this file. Do you understand that, sir?
Yes.
And you're represented by Mr. Hess from the Public Defender's Office. He would cross-examine any witnesses and contest any charges brought against you in this case. Do you understand that?
Yes.
It's my understanding that you wish to have this prelim moved with the other prelim and set with the other prelim, which will be outside of the 21-day rule. So you'll be agreeing today to waive your right to a prelim only within 21 days, not to a prelim in general, only to your right to a prelim within 21 days. Is it your intent today to waive your right to a prelim within 21 days? Yes. All right. I find the waiver of the prelim to be knowing, voluntarily, and accurately made, and we will set this file 2301-661 along with 23-01607 as part of the proofs for whatever date we come up with. All right. Anything else on the record, Mr. Hess?
No, nothing further. Thank you.
All right, Mr. Yang.
Nothing further for client Jessica P.
Mr. Johnson.
No, Your Honor.
All right, Mr. Stevens.
Nothing from the people.
All right, so we will wait to get a date certain for an afternoon of testimony in these files. Thank you, everybody, for your appearance.
Thank you, Your Honor.
And Mr. Johnson, you're free to leave the Zoom courtroom, and Mr. Conley, you're free to leave the Zoom courtroom. Thank you.
What about my other case?
That case has been consolidated, and we're gonna have both exams on this new date.
But then that's 40, it's been 41 days since my preliminary examination. Like, I mean, since I've been arraigned, how many times can they adjourn a case? For the 01236.
Yeah, Mr. Johnson, would you like a breakout room with Mr. Conley?
Yes, Your Honor. But he's got jail staff in the room. It wouldn't be confidential. So
right. So Mr. Johnson will be in a position to contact you in order so you can discuss some of these matters. Okay, sir?
Your Honor, you have me in the hole. They won't let me write nobody. They don't let me.
Mr. Conley, we're not discussing your case anymore. You're in front of law enforcement. You've got your lawyer present. I think you should wait to talk to him in a privileged situation. All right, sir?
Yeah.
All right, Mr. Johnson, I'm assuming you'll be in contact with your client.
I've been having some issues with, getting through to the jail, but we will make it happen.
All right, thank you.
Thank you.
people of the state of Michigan versus Isaac Alameen. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sartz, fourth Assistant Public Defender here on behalf of Mr. Alameen. He's president of council table to stay in America.
And sir, you are Isaac Noble Alameen?
Sir.
All right. This is the time set for a preliminary examination. Mr. Pfeiffer, it's my understanding the people are ready to proceed.
Yes, Your Honor. Both of our lay witnesses are here and prepared.
All right. And then Mr. Sartz, you're requesting an adjournment. You may proceed.
Thank you, Your Honor. Mr. Alameen informs me that he would like to retain Vince Green. His father is with them today. It's my understanding they are in negotiations right now to retain Mr. Green's services. Your Honor, of course, is very familiar with Mr. Green. Mr. Green has practiced in the community for a very long time. I certainly would not want to be in a position, Your Honor, where my strategy might be different from Mr. Green's, or we get a circumstance where Mr. Green might have had different questions or different approach to the preliminary examination. And if they're close to retaining them, and it's my understanding that they are, Your Honor, a brief adjournment. I would just simply request a week or so, or a couple weeks, Your Honor, on behalf of Mr. Alameen. If the witnesses are here today, certainly I understand the prosecutor's position on it, but that would suggest that they're on board, that they're cooperating, that they have good communication with the prosecutor's office. And well, they've been inconvenienced for a couple hours today, Your Honor. Certainly, it appears that they would be in a position to appear at an adjournment date as well. Certainly, this request would be a delay attributable to the defense. The defense understands that, Your Honor. But certainly, I do not want to be in a position as a public defender where I'm possibly interfering with the potential strategy of a different attorney, especially if the family is close. And Your Honor is certainly very familiar with Mr. Green, as am I. He's a local, reputable attorney. He's been in the area a long time. So I take his representations to me in good faith that they're close to retaining Mr. Green here. And under the circumstances, Your Honor, I just request a brief adjournment of today's preliminary examination.
And Mr. Sartz, if I were to grant your motion, then I have not made a determination in that regard. But your client would be willing to waive his right to a prelim within 21 days?
Absolutely, Your Honor.
All right. Mr. Pfeiffer, response?
Your Honor, the people would strongly object to this request. The victim and the eyewitness are here. They are ready to testify. And I have no doubt that Mr. Green is a good attorney. Everyone here knows that. But we aren't hearing any of this from Mr. Green. We aren't even really hearing any of this from Mr. Sartz. We're hearing about from Mr. Alameen, who says that he's close to getting Mr. Green now that he sees the victim is here and willing to testify. I will note that when he was still in the jail on 5/31, he was calling his family saying how they needed to hire Vince Green. And that was 16 days ago. And they haven't. This is a delaying tactic, Your Honor. I would strongly object to it. I'd ask that we go forward today, as is the people's right to do so. I do not believe that Mr. Sartz is going to be interfering with another attorney's strategy or anything along those lines.
He does make an argument, but I do have, so this is my intended purpose in this is, this is what I would intend. So I'm going to deny the motion and move forward, but I'm going to move forward in a way where I believe that everybody's rights are somewhat protected in this matter. Since the witnesses are here, we've inconvenienced them. They can take the stand and they can testify today. We'll have our prelim. The cross can be done by Mr. Sartz, but then we'll adjourn that matter. And if Mr. Green becomes a part of this, he can make his own cross-examination. We'll come back for another date, okay?
But he would be present for the direct.
Your Honor,
he would not be present for the direct because he's not here today.
Yeah,
because we have counsel here today.
That's why I think we just need to go forward and end it today with the counsel he has.
I want to have Mr. Green the opportunity to review the documentation and to cross-examine if he chooses based on the review of the direct testimony. I think that's fair. If Mr. Green chooses not to be involved, then we can address those issues at the time. But I do think Mr. Sartz makes a good point that he may have a different strategy in cross-examination that's different from Mr. Green's.
Yeah, but he'll be able to do that at trial. That's the thing. I don't think it's going to work to switch attorneys mid-preliminary examination. I don't think it's possible.
Well, I think it is because I think Mr. Green can review the testimony and he can look for his own cross-examination purposes.
But the only testimony he'd be able to review is Mr. Sartz's notes. He's not gonna have a transcript or anything like that.
I could order a transcript.
Your Honor, then we have to sort out who's going to pay for the transcript, and respectfully to Wendy and the court reporters, they already have a big
All right.
backlog of cases.
All right.
Your Honor, I'm just requesting a brief adjournment here. Give Mr. Elamine a week or so to see if we can get the contract in place. Respectfully, it would be a lot cleaner. I understand it's been 16 days. I was in private practice over 12 years. I understand that process can take a little while sometimes, but his dad is here, Your Honor. And they have assured me that they're in the process of trying to retain him. Your Honor, respectfully, please, I would just request a brief adjournment to allow Mr. Elamine. It would be much cleaner for the court, much cleaner for the complaining witness and whoever else the prosecutor is going to call in terms of direct and cross and getting transcripts and all these other issues, Your Honor. Thank you.
And Mr. Pfeiffer, your witnesses are here today, correct?
Yes, we're ready to start and end today.
And if they understood that they're still on subpoena, they understand that that if I was to make a brief adjournment, they're still under subpoena.
They do, Your Honor.
Right. So they're still required to be here.
Correct, Your Honor. But, I mean, you've heard my objection.
Right. And this is a valid objection, and this is it's a valid objection. The witnesses are here. I'm going to grant the motion to adjourn. I'm going to indicate for the record, and you can indicate this to the subpoenaed witnesses that they're still under subpoena for whatever date we choose. So if they're in violation of that subpoena, we can show cause them. We can even bench warrant them. I do expect them to be here. They're here. They're here now. This is a, but I do want defense. I do want the defendant to have a counsel of his choice.
Understood, Your Honor.
So
And
I'm gonna.
to that point, I don't think they need to be reminded. I don't think there's anything on their behalf that would make them willingly not
All
be
right.
here.
All right. So I'm going to grant the motion to adjourn, and we'll reset the date. Now, what I'm afraid of is we'll get Mr. Green in here and it'll ask for another adjournment because there's discovery purposes. So when you get Mr. Green, he must know that the new date is the date. Okay, that's the new date is debt for prelim. I will most likely be denying any motion to adjourn unless he simply does not have any discovery. Okay, and I know that once you get him, he'll file an appearance and discovery will be made. So we will reset it for 2 weeks.
Yeah.
Yeah. So the closest we have to 2 weeks. The closest we have for 2 weeks. Yeah. And I do expect testimony, so we could put it on a different date if it works with everybody's schedule.
That might be best.
Yeah.
It's likely be lengthy.
Right. So let's put it for an afternoon.
6/29 at 1:30.
June 29th at 1:30.
I'm checking right now to make sure I'm not in trial.
That should work for the people.
Yeah, it will.
All right. You'll get notice from our court officer too. Okay, we've reset this. Testimony will be taken on June 29th at 1:30. We've got some time set aside for it. Oh, he does. You're right. So Mr. Sartz may inquire of your client of his waiver of his 21-day right.
Yes, Your
21-day
Honor.
rule. All right.
Thank you.
So, Mr. Alameen, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. Do you understand that? Mr. Sartz is here to represent you today. You may have Mr. Green later, but they would be here to cross-examine or contest any charges brought against you by the state of Michigan. Do you understand that? Is it your wish today to waive your right to a preliminary examination within that 21-day period? You wouldn't be waiving your right to a prelim in general, just within that 21-day period in order to have counsel of your choice. Okay. All right. No, that's fair. So I find the waiver, the 21-day rule, to be knowing, voluntarily, and accurately made. And we will reset this preliminary examination for June 29th at 1:30. Anything else for the record in docket 23-01542, Mr. Pfeiffer?
Yes, the people would like to address bond in this matter.
All right, you may.
The defendant is facing 11 counts with this victim, including assault with intent to murder, home invasion first degree, unlawful imprisonment, strangulation, multiple counts of felonious assault, multiple counts of domestic violence, and multiple counts of felony firearm. These are very serious charges, and the facts underlying them are some of the most dangerous I've seen. Further, upon speaking with the victim, she informed me that the defendant has a history of trying to have her not appear at court, and for the last case in 2021, actually ripping up her subpoena. Because of all of this, Your Honor, I feel the $25,000 cash surety bond that was made is categorically inadequate for the charges he is facing. I believe $75,000 cash surety is much more appropriate. That's me being conservative. Ideally, it would be six figures.
Mr. Sartz, your response to the motion to raise bond.
Thank you, Your Honor. The defense would object very strongly to that request, Your Honor. $25,000 cash surety bond is more than sufficient deterrence against any sort of flight, and more than sufficient deterrence to ensure that Mr. Alameen will comply with all the court's orders. Mr. Pfeiffer is not alleging, Your Honor, any violations of any bond conditions at this time. He's not alleging any violations of any no contact orders. The family had to put up quite a bit of money, Your Honor. Mr. Alameen qualified for a public defender, so he is indigent. And that amount of money, Your Honor, is a very significant amount of assurance that Mr. Alameen will comply with all the court's orders. His father is here today, Your Honor. There's been nothing shown so far that Mr. Alameen will attempt to flee or anything along those lines. Respectfully, Your Honor, the prosecutor's office had the opportunity to put a request in when he got arraigned. They chose not to do so. He was given his current bond amount by the magistrate, who had the knowledge at the time based on the swear to and the other information in the file. It was a fair and reasonable bond given the charges. His family was able to post it. And quite frankly, Your Honor, it is reasonable. Mr. Alameen will continue to comply with all of his bond conditions. He knows about his court date. He'll show up for that one too. He's made all his court dates so far, Your Honor. And I will be ready to go on the 29th for his preliminary examination if things don't work out with Mr. Green. So respectfully, Your Honor, I would just simply request that the court keep the bond as it's currently set. And if the court feels it's necessary after the preliminary examination, certainly that would be an opportunity to revisit the issue. Thank you.
Mr. Pfeiffer, is there any criminal history concerning this matter?
Yes, Your Honor. In 2021, he had a case involving felony assault behavior against this victim. And then further, he assaulted jail staff once he was arrested.
Those are both convictions.
The conviction is for assaulting the jail staff. If you might remember, I said he tore up her subpoena, so she never appeared at court last time. Further, it is inaccurate to say that the people had an opportunity to be at his arraignment and didn't. We are not told when defendants are arraigned. We find out after the fact. What we do is we fill out bond forms for recommendations with the magistrate, which we did. And we laid out these concerns and we said that we need a high cash surety bond. But the prosecutor's office and the magistrate have very different definitions of high cash surety, apparently.
Well, the bond was set by Judge Ward. I think that this was a weekend arraignment or a Wednesday arraignment. This bond was set with $25,000 cash or surety. The public defenders is representing Mr. Alameen.
Apparently not for long.
So there is some money involved in this. It's $25,000 cash or surety. There's a GPS tether ordered with an exclusion zone. So I'm assuming Mr. Alameen is on a tether. All right. And the continued no contact, and I'll indicate this for Mr. Alameen and for anybody who's associated. There's a continued no contact order with Miss Western and with Chloe Lynn Western and Dana Western. I'm not going to override the $25,000 cash or surety at this point in time. However, I will look at a bind over proceeding in order to reevaluate that $25,000 cash or surety. I think Mr. Starts makes a good argument that this was set by a judge at arraignment. But I'm indicating for the record, I will reevaluate bond after the preliminary examination. All right. So the motion to raise bond is denied at this time and will be taken up at the preliminary examination. Anything else on the record in docket 23-01542, Mr. Pfeiffer?
Not for the people, Your Honor.
Mr. Sarts?
Nothing further. Thank you for
All right,
correcting
thank
the
you.
record, Your Honor.
All right, so Mr. El-Amin, you're all set. Thank you for your appearance.
Thank you.
Let's bring Ms. Whitson up.
Is that McLean in the jail?
Yes.
Okay. We potentially handle.
No, yes, after this, McLean's yours, right?
Yep.
Because that file I already wrote in, and then I had to scratch it all out.
Yep.
So are you Miss Woodson?
Yes, I am.
All right. Let me grab your file, because I know you've been waiting patiently.
Oh, yeah, absolutely. Do yeah, comes. So I'm gonna go let my witnesses know for LME and I'll be right back.
All right, thank you.
We have a name for a co-defendant, Eric Lamal, might be.
Judge will hear the PCC is next Friday, so Judge will be back here then, but I will email Mr. Jamal as well.
So it's Mr. Tamal as conflict counsel.
It appears at this point, yes.
Thank you, Mr. Smith.
4-8. Why do I have this? 23-00969. I don't know why I have that file. What's that? I need 23-00487. Island. 487. I'm not sure why I have that. All right. So we're on the record in docket 23-00487. That is Andermark Rivershell versus Nora Woodson. This was the time set for a motion on this matter. And this was your motion to set aside the conviction. And the motion is looked at as in regards to a reason for the previous, so this was a conditional dismissal, is that correct, ma'am?
Yes.
All right. But it does appear that nobody from Andermark Rivershell has appeared today, and therefore I'm going to grant your motion, okay?
Okay.
And we will, so motion granted by default, I'll indicate. By default, plaintiff did not appear. And then what I'm going to do, ma'am, is I'm going to set this for formal hearing, okay?
Okay.
So bring in any evidence you want me to consider concerning this case. Feel free to contact Andermark Rivershell in regards to some of the things you indicated in your motion. But I'm going to set it for formal hearing, and let me get a date for you, all right? And you'll get notice of that date. So we want to set it on that July date. We had some,
July or June?
we're in the middle of June now, so let's do. So didn't we have a July
We do have
20? What's that?
We do have some July. I
Yeah.
just didn't know if we wanted to.
No. So give me one of those July dates. We used up yesterday, like 17th or 18th.
That's what I was trying to remember. Thank you.
They were Monday and Wednesday, but I'm not sure which.
July 19th at 3.
Okay, July 19th at 3. So ma'am, your formal hearing is set for July 19th at 3. You should treat that like a trial date, okay? So bring in any evidence you want me to mark, okay? And in the meantime, if you want to contact your property manager at Rivershell to see if this can be worked out some way, based on your motion to set aside the judgment, it appears that there's some contradiction concerning what's owed and what's not owed, okay?
Right.
So maybe we can work that out beforehand, but appear live in person on the 6th floor, just like today, on that July 19th date. And thank you for waiting so patiently.
Thank you.
All
Is there
right.
somewhere I can get paperwork?
You should get a notice right from my court officer.
The mail?
No, right now, he's gonna give you a copy, okay?
Thank you.
If you stand right there, he'll give you notice.
Thank you very much.
What's Mr. Colwriter?
I have several cases. I'm prepared to proceed on. We have Mr. Goodrich in the courtroom, that's Mr. Peterson.
Okay.
Mr. Austin's in the courtroom, Mr. Garza is in custody, that will be a plea.
Okay.
And I have 3 cases with Mr. Milks, who I've not seen for both of them.
Yeah, we had Mr. Milks in here, and then he's a very popular guy.
I believe Mr. Mills is down at Judge Buchanan.
All right. So whatever case you want to call next.
We can take care of Mr. Goodrich.
All right. Is that Mr. Adrian Person?
Oh, that's correct.
Make sure I've got the right, here we go on top. All right, so we're on the record in docket 23-01518. That is People of the State of Michigan versus Adrian Person. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Dale Falter on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Person, who does not appear to be present.
All right, this is the time set for a probable cause conference in front of Judge Simmons. This court is covering Judge Simmons' PCCs today. This was initially set for 9 o'clock. It is now 11:15. It would appear that Mr. Persons is not in the Zoom courtroom. Is there an Adrian Person in the physical courtroom? Mr. Goodrich has indicated his client's not here, so the court will issue a bench warrant and bond forfeiture. Mr. Colwriter, any comment on that?
No, Your Honor, we would just ask for that bench warrant bond forfeiture, and that'd be based on the nature of the charge being assault.
All right, Mr. Goodrich?
Your Honor, I'll just state that I did try to reach out to Mr. Person, but his phone was no longer in service.
All right, then I'm not putting a 48-hour hold on it because of the nature of the assault, and it's assault GBH tenure. So so at the PCC, defendant has a bench warrant and bond forfeiture. Thank you for your appearance on 23-01518.
Okay, thank you, Your Honor.
And then on Mr. Colwriter, what's the next one?
Well, Mr. Milks is not here. Mr. Austin is, but I believe his client is still downstairs in custody.
All right.
Your Honor.
And is that the plea?
That will be a plea, yes.
All right. So, yeah, you can go get him. Yeah.
Your Honor, while we're waiting for that, can we go on Shane Cox?
Sure. Mr. Cox is.
I have some
All right.
officers who worked overnight. I'd like to go home.
All right.
Then move it in custody. Yeah.
All right, so we're on the record in docket 23-01664. That's People of the State of Michigan versus Shane Michael Cox. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Cox, who's standing to my right.
And sir, you are Shane Michael Cox?
Yes, sir.
All right. This is the time set for a preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, after speaking with the defense, I believe the people would be asking to dismiss count 1, receiving and concealing the motor vehicle. And upon the dismissal of that count, the defendant would then be unconditionally waived. Well, I guess on the condition of that dismissal, the defendant would be waiving any preliminary exam on count 2, the delivery manufacture of marijuana.
Count 2. Is that your understanding, Mr. Goodrich?
Yes, Your Honor.
All right. And so we can do it. So are you going to dismiss that as part of the condition, or did you want to dismiss that here?
I mean, we can dismiss it here, Your Honor, and then just waive up and waive up on count 2.
Yeah.
I wasn't sure how the court wanted.
It's not up to me. It's up to you. I mean, if we can waive with the understanding that count 2 is supposed to be dismissed, or count 1 is to be dismissed, or I can just dismiss count 1 and we waive up on count 2.
I think that's probably.
Yeah, Your Honor, I think dismissing count 1 here.
Yes.
Okay.
Yeah.
So we'll prepare a nollie pros for count 1, for it to be dismissed, and that's the understanding, and waiver will be on count 2.
Yes.
Okay. May I inquire of your client of his waiver of the preliminary examination?
Yes.
All right. Mr. Cox, you understand, then I'll ask you some questions, so you'll have a chance to speak, sir. Just remember, just speak about the process, not about the facts of the case. It's my understanding that you want to waive your right to a preliminary examination in this matter and have this case bound over to circuit court on count 2, which is the controlled substance count. Count 1 will be dismissed today at district court. That's my understanding from what the attorneys have said. Is that your understanding today?
My understanding was the owner wasn't here of the truck, and I didn't know that was gonna affect the outcome on
Right. So the people are not moving forward on that count 1.
So that's being dismissed because the owner's not.
Right.
But yes.
Right.
Yes.
All right. So with that, is that your understanding? The count 1 is to be dismissed today, and count 2, you'll go, negotiations are to continue in circuit court on that case. All right. Is it? So you understand you have a right to preliminary examination within 21 days of your date of arraignment, sir. Right. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. Do you understand that? You, of course, are represented by attorney Luke Goodrich, and he would be present to cross-examine any witnesses and contest any charges brought against you at that preliminary examination. You understand that, sir? It's my understanding, based on negotiations that have been indicated for the record, that you intend to waive your right to a preliminary examination only as to count 2. Count 1 is to be dismissed at this time. Is that correct?
Yes, sir.
All right. Is it your intent today to waive your right to a preliminary examination? All right. Mr. Brodowitz, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
And do you have a nollie process for the courts?
Yes, Your Honor. May I approach?
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will sign the nollie process to count 1. Mr. Cox, your time in district court is done. You'll get any new date from your attorney, Mr. Goodrich, in circuit court where count 2 is bound over as charged. All right, sir? And I'll have that on count 2. Count 1 dismissed. And I'll have you sign the bind over in that regard. There you go.
I also apologize for my tardiness this morning.
You're all right, sir. We've had plenty to do this morning.
I tried to call in the whole way here, so.
Thank you, Daniel. All right, the bind over sign. Thank you for your appearance today.
Thank you, Your Honor.
All right, thank you, Mr. Goodrich. Then, Mr. Colwriter, did you have any other?
Yes, we have a plea here on Mr.
All right, Mr. Austin. Judge Simmons. Okay, that's him on, all right.
That's Levon, but there's also some matters, Mr. Pfeiffer and Mr. Hess want to put on the record.
Okay. You may. Executive Vice President. All right, thank you.
Not a problem.
All right, we're on the record in docket 23-01174. That is People of the State of Michigan versus Angelo Santino Garza. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Dale Coltrader on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Garza. He stands present to my left in jury box.
And sir, you are Angelo Garza?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference in front of Judge Simmons. I'm covering Judge Simmons' probable cause conferences. Mr. Callwriter, how are we proceeding?
Your Honor, it's my understanding at this time, the defendant will be entering a plea to an amended count 2, which would be attempted fleeing and eluding in the 4th degree. Should that plea successfully enter, he will dismiss count 1, fleeing and eluding in the 3rd degree.
So this would be a plea to the 1 year attempted flee and elude?
Correct, Your Honor.
And what's the fine on that? That's a 1 year and or?
It's $2,000.
I think it's 2,000. The amended count to flee and elude 1 year and or $2,000 fine. So it's attempt flee and eluding 4th?
Yes.
Pursuant to 257.602A2. And Mr. Austin, is that your understanding? I'll restate the plea agreement for the record. The defendant, Mr. Garza, is going to plead guilty to count an added count 2 of attempt flee and elude under 257.60T 602 parents A, parents 2. That's a 1 year and or $2,000 with a plea to the amended count 2. Count 1 is to be dismissed.
That is my understanding of the agreement, Your Honor. That's what I've conveyed to Mr. Garza.
All right. May I inquire of your clients of his advice of rights? I see Mr. Austin.
Yes, Your Honor.
Mr. Garza, I see that you have signed an advice of rights indicating that you understand your misdemeanor rights in this case and that you're waiving them in order to plea. Is that correct?
Yes, Your Honor.
All right, and I'll put that in the court's file. I'll just go over 3 quick rights with you to highlight these rights. You understand you have the right to trial in this matter? You understand that?
Yes.
You understand you have the right to counsel. You, of course, are represented by Mr. Austin today, and he would be present to contest any charges or cross-examine any witnesses at trial.
Yes,
You understand that?
Yes.
All right. And you understand that you have the right to silence. You have the right not to be called by the prosecutor in this case, and you have the right not to have that silence used against you in a court of law. You understand that?
Yes, Your Honor.
All right. Is it your preference today to waive your rights and plead guilty today?
Yes, Your Honor.
All right. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Now I'm going to bring your attention back to April 13th, 2023 at the offense location of East Cesar Chavez on Larch Street in the city of Lansing. Were you operating a motor vehicle on East Cesar Chavez in the city of Lansing on April 13th, 2023?
Yes, Your Honor.
All right. And at that time in count 2, were you given a visual audible signal by hand, voice, emergency light, or siren by a Lansing Police Department officer who was in uniform or who was in an LPD vehicle that was marked?
Yes, Your Honor.
Okay. And at that time, did you willfully attempt to disobey an order to pull over or something along those lines?
Yes, Your Honor.
Okay, you can tell me, what was it?
It was something along those lines. Yes, Your Honor.
When you say something along those lines, what do you mean?
I refuse to stop.
You refuse to stop the vehicle? All right, all right. And so that all occurred on April 13th, 2023?
Yes, Your Honor.
All right. I find any questions concerning the factual basis, Mr. Callwriter?
No, Your Honor.
Anything concerning the factual basis, Mr. Austin?
No, I'm satisfied, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. And in this 1 year and or $2,000 case, which is the ultimate penalty, we will refer to probation for a pre-sentence report. Most likely you will be sentenced by Judge Simmons, okay?
Yes, Your Honor.
All right. So, and I don't know the state of your incarceration, but if you are released, it's important for you to get to probation. Otherwise, probation will be down to see you. What they're going to do is they're going to ask you lots of questions, prepare a report, and you'll see what options are available for your sentencing date, okay?
Yes, Your Honor.
All right. Do you have a sentencing date for Judge Simmons?
Yes, August 10th at 9:30.
Okay, August 10th at 9:30 is your date of sentencing. So August 10th at 9:30 is your date of sentencing. Anything else for the record, docket 23-01174, Mr. Callwriter?
No, Your Honor.
Mr. Austin?
Just a couple brief
Okay.
matters, Your Honor. It doesn't appear that Mr. Garza is being held in custody on this matter. He's being held on other matters, so I'm not going to address bond today. I would just ask that be continued.
Okay.
And I did speak with Mr. Garza that he would likely have a different judge sentencing him than the one that took the plea, and we have no objection to that.
Thank you. So bond is continued in the matter and sentencing will be in front of Judge Simmons. That's all for the record, docket 23-01174. Good luck, Mr. Garza.
Jeff, are you okay with?
Mr. McLean, right?
Yes, Judge.
All right. And sir, you are Tavel McLean? I don't hear him.
Mr. Eisenman, just,
Mr. McLean, can you identify yourself again? I can't hear you. No, I can't hear you.
We have another case we're ready to go on, Your Honor.
All right. For whatever reason, I can't hear you, Mr. McLean. You might want to check your mute status or contact somebody in the jail. Yeah. All right. What case is that, Mr. Hess?
Mr. Joshua Eisenman.
Eisenman is
8:30 a.m. Your prelim, Your Honor.
all right.
Yes.
It's right here. All right. I got a little bit of everything today. All right, so we're on the record in docket 22-0076. That's people of the state of Michigan versus Joshua Eisenman. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Edward Hess on behalf of Mr. Eisenman, who is present, standing to my right in the courtroom.
And sir, you are Joshua Eisenman?
Yes, Your Honor.
All right, thank you. This is the time set for a probation violation in this matter. Mr. Brodowitz, how are we proceeding?
Well, I think it would be cleaner for this matter, Your Honor, if we started with the preliminary exam.
Oh, that's
And
so
then-
that's the second file.
Yes.
So the first file is 1645, and that is the felony preliminary examination. Is that a yes?
Yes, Your Honor,
Okay.
sorry.
All right. All right. So this is the time set for preliminary examination. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor. As you stated, today's the date and time set for preliminary examination. The people have subpoenaed witnesses, but however, those witnesses have not appeared. I have called the hallway in the courtroom. And like I stated, they have not appeared. So at this time, the people would be unable to proceed.
Based upon that, Your Honor, defense moves to dismiss without prejudice.
All right, so the people move to dismiss this file 23-01645 based on the inability, insufficient witnesses and unable to proceed. No. Should be one felony count and I will grant the motion to dismiss without prejudice, Mr. Eisenman, which means that on today's date, the case is dismissed. It may be reissued by the prosecutor, but for our purposes, this case is dismissed, and I will sign the nollie to that effect in just a second. All right. So I've signed a nollie to that effect. Anything else for the record, docket 23-01645, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right, Mr. Eisenman, on this file, you're all set. Thank you for your appearance today. And then we have the second file, which is the violation of probation file, docket 22-0076. And parties have already introduced themselves for the record. Mr. Brodowitz, how are we proceeding on the probation violation?
Yes, Your Honor, at this time, as I believe the violation of probation was for the previous file, that would be 23-01645 FY, which the people were unable to proceed on and the court has dismissed. The people would not be able to proceed on the violation of probation, so we'd be recommending that the court dismiss that violation.
Yes, Your Honor, defense moves to dismiss the probation violation.
All right. So the allegation today is that you violated probation by two non-technical violations. The people have indicated they are unable to proceed today. Proceed with the probation violation hearing. And so these technical violations are dismissed. Since the people are unable to proceed. So both two technical violations are dismissed. Anything else for the record in this docket? Let me see if I can find that nice. Docket 22-00076, Mr. Brodowitz.
Nothing from the people.
All right, Mr. Hess?
Nothing further, thank you.
All right, Mr. Eisenman, you're all set. Thank you for your appearance today.
Take care.
Mr.
Spoke with the gentleman, they indicated they were able to get the room unmuted.
Okay, so let's go on Mr. McLean. So, sir, you are Tavel McLean?
Yes, Your Honor.
All right, perfect. And you can hear me all right, Mr. McLean? You can hear me all right, Mr. McLean? He didn't, that I didn't hear what he said. All right. McLean is
PCC.
This one of mine.
Judge Moore.
Judge Moore.
Last PCC on our docket.
I'm running out of. Simmons. Is this your last one on Word?
Yep.
Okay. That's why my case is. There we go.
I don't know the process.
That's me.
It's Mr. Pfeiffer.
I'm sorry.
It's okay.
Oh,
All right.
you did say that with that.
I'm used to you overlooking me, Wendy.
So we're on the record in docket 22-03263. That's people of the state of Michigan versus Tavel McLean. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Edward Hess, appearing on behalf of Mr. McLean. I had the opportunity to meet with Mr. McLean a few days ago. However, today he's appearing by Zoom or Polycom from the county jail.
Okay. And sir, you are Tavel McLean, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference in front of Judge Ward. I'm covering Judge Ward's PCCs today. Mr. Pfeiffer, how are we proceeding today?
Your Honor, there is no offer at this time. The people request that this be left on for examination, and the people are also going to make a request as to his bond and jail privileges.
Is that your understanding, Mr. Hess?
Yes, Your Honor. I got an email last night, or I shouldn't say night, afternoon, from docket prosecutor Ms. Castleman saying that there were some allegations that I'll let Mr. Pfeiffer put on the record, and that she would be asking for an adjournment. My understanding is that since Mr. Pfeiffer has taken over, he's no longer asking for an adjournment, but I would allow him to make his record as far as whatever allegations there are and whatever bond motion he wants to make.
All right. So in regards to probable cause conference, we're leaving it on for preliminary examination on June 22nd.
That's correct.
2023 at 8 a.m. And Mr. Pfeiffer, would you like to be heard on bond?
I would, Your Honor.
Okay, you may proceed.
Now, yesterday afternoon, this was Ms. Castleman's, and as of this morning, it is now mine. However, did some work this yesterday afternoon for her, and I discovered that the defendant had been contacting the victim very frequently from the jail. And then I discovered video visits this morning once it became mine, and I did a more thorough search. He has sent the victim 32 e-messages. He has called her 71 times from the Ingham County Jail, 39 times from LPD lockup, and they have already had 13 video visits together. And he's only been in for a few weeks. As a result of this, Your Honor, the people have already requested that a detective be assigned to this case so that way the detective can investigate this further and determine whether there are any witness interference concerns at play. I don't know how quickly a detective is going to be assigned. Hopefully it will be done by the end of this week, and an adjournment will not be necessary for the preliminary examination date. But I made defense aware that if it gets to the point where the detective wasn't able to be assigned in time, given the time frame, an adjournment request might be made next week. But as we're here today, I would ask that his bond be revoked pending the preliminary examination, and that all of his jail privileges be completely revoked, that being his phone privileges, his e-messages, and his video visits, as he has decided to contact the victim through all three ways. He is calling her number that we have listed in the police report. It's also her number that has her name attached to it in the jail system. He is sending messages to her in her full name from his own account, and he's doing video visits with her in her full name from his account.
All right. Mr. Hess, any response? I know some of this information is brand new to you.
Well, Your Honor, I just want to make sure that we're accurate as far as bond goes. I'm not sure if bond has been posted, so I'm not sure it could be revoked. If it hasn't been posted, I would ask that it just stay as it is, since clearly Mr. McLean is unable to post it. As far as the conditions of Mr. McLean's incarceration, that's something that I'll leave up to the court. Mr. McLean's clearly aware of the no contact court orders, and any communication that he's allegedly had with the alleged victim would be against those court orders. So if the court orders the jail to restrict Mr. McLean's ability to communicate with anybody who's not his attorney or medical staff or jail staff, that would be within the court's powers to do that. And that's not something on which I would take a position. I would ask to reopen it next week because people need the support of their family. But if the prosecution is able to prove that he's been violating court orders, then that's something that's very concerning to me. Clearly, at this point, he pleads not guilty to any alleged no contact violations.
So I will indicate for the record that the initial bond was requested was 30,000 cash or surety, which was the bond that was set. It appears that, I don't know if Mr. McLean has been able to make that or not, but the allegation is that there's numerous attempts to violate the pretrial release in regards to the no contact order. So I'm not going to revoke bond, but I'll raise bond. So bond is raised to 60,000 cash or surety, and I will revoke any privileges at this time, except for, of course, counsel for attorney visits in regards to discussing the case. But privileges are revoked, and I'll revisit that, or I'll indicate that Judge Ward will revisit that to revisit at preliminary examination. Anything else for the record in docket 22-03263? It's left on for prelim on June 22nd at 8 o'clock. Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Hess?
Nothing further, thank
All
you.
right, Mr. McLean, you're left on for preliminary examination on June 22nd at 8 o'clock. I will remind you that there are several no contact orders that are at the heart of this, and you are to have no contact with Shalitha Miller. Do you understand that, sir?
Yes, Your Honor.
All right, that's all for the record in 22-03263.
Thank you, Your Honor.
Thank you.
Mr. Harris.
Thanks for whiting that out. All right. We did Mr. Element, right?
I'm not sure what else there is to say about that one.
Did you do Mr. Cox on ours?
Yeah.
Okay.
It looks like we have
Out of here.
It's like being in the bar.
Elbow your, elbow your way up to the bartender.
Okay, Kalamazoo and car.
We did well.
Person.
I don't have wells.
Good luck.
In person?
Alright.
Okay. We did person.
Let me find, hold on. Let me get this. So we did Kazovac, we did Carr, we did Person.
Yep.
How about Williams? Chesky? We've
Williams
done,
is actually gonna be this afternoon.
okay, we've done Wells, Arnett. Benitez.
Yeah.
How about Garza?
We did Garza, yeah.
Okay.
The rest were waiting on.
All right.
I believe we're missing Mel too.
I'm here.
Oh.
Hola.
Hola. I can't hear all that.
That's fair.
So this is this afternoon. And then we have Mr. Brodowitz, we have Miss O'Reilly. Are you ready, Miss O'Reilly?
Yes.
Mr. Abbott?
Yes.
Okay.
There's a violation.
All right. All right.
And then Dale says that they're not.
You're aware, check if he's,
Clinton County writ.
he is here in Clinton County, right?
That's what my sheet says for that.
Okay. Yeah,
If he's here or not. I
So
don't know.
do we have a bond violation?
No, but it was just. They don't actually do a formal violation, they just send us.
And how are we supposed to have a hearing on it? All right. So we're on the record in docket 22-2303 and 22-03192. That's people of the state of Michigan versus Courtney Lynn O'Reilly. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney John Abbott representing Courtney O'Reilly. She's standing on the right.
And ma'am, you are Courtney Lynn O'Reilly? Okay. This is the time set for, on two files, I have a review and then I have a pending memorandum, Mr. Abbott. I don't know if you've seen this concerning an allegation that your client has failed to test to report for drug or THC. Have you seen that?
No.
Okay, I would assume not. So let's take care of the matters at hand, and then I'll provide you with that memorandum. Okay. So this is the time set for a review hearing on both of these files. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After conversations with the defense, I believe that Mr. Abbott has been in contact with the treatment or placement. I'm not sure exactly, and he can fill in. But that based on the fact we're coming up to the timeline, and he has a letter stating that at least on file 22-03192-FY, that the defendant will not be able to receive treatment before the timeline runs. And so in that case, I'll let Mr. Abbott fill in here, but then with that, the people would have just one small matter.
Okay, so this is, let's go on the first one on 22-02303. And Mr. Abbott, you're indicating there's a timeline issue because the report's not finished on the, but go ahead.
Thank you, Your Honor. I have a letter from the Forensic Center that's addressed to you, and I'm hoping you've received it. If you haven't.
I have. That's a January 23rd letter?
No, June 5th, Your Honor.
I do not have that letter.
May I approach?
You may. All right. Okay. So let me just make sure that I don't have it on file 023. I don't have anything on that file. And I don't have anything on that file. So my last letter for the record is dated January 23rd, 2023. And that was concerning a competent stand trial. And so I'm going to indicate for the record that I'm looking at a letter that was dated to me, but I don't have it. That Mr. Abbott, public defender, has indicated this to establish court relative lapse before the defendant is able to be admitted for hospitalization. Consequently, course of treatment and competency cannot be provided in this matter. Please note, defendant remains on the MDH for competent for treatment for Your Honor's order dated for the charge of treatment period of 457 treatment days. As such, it remains on our admission. All right, so in regards to this file, it appears that there's a letter that I've not received yet in regard to 22-02303. Yep. What's that? June 5th, 2023. So you can take your laptop, Mr. Abbott. That would indicate that the defendant will not be reviewed, will not be found competent within the required time period. Is that correct?
Right.
All right. With that understanding, Mr. Abbott, how do you want to proceed?
Well, Your Honor, I guess I should inform the court at this point that she's certainly made, Ms. O'Reilly's made great progress in dealing with her mental health. She has an ongoing relationship with CMH and regularly meeting with people there. She's also obtained full-time employment with Peckham. She's supporting herself, and she's most importantly, Your Honor, reestablished that relationship with the CMH regarding mental health and substance abuse issues. So she is obtaining the kind of treatment that would be provided had she been admitted to a facility. So I guess as far as that goes, I understand that the prosecutor has a motion regarding civil
commitment.
Thank you. And I think the alternative is what she's doing right now, so it won't be necessary. Thank you.
All right, so this is in regards to file 22-0230230. And it's my understanding that this was set for forensics review. The request was made as early as September of 2022, was set for review on September 30th, was set for review on September 29th and for December 29th. We had some bond violations and admission. We scheduled a hearing for April 6th on a positive test. I have on March 23rd, the defendant pled the use of methamphetamine. I'm assuming that has to do with the pretrial, the other case. Okay, all right. So, Mr. Brodowitz, what's the people's position on docket 22-02303?
Yes, Your Honor, being as the defendant would not be able to be seen in time under the timeline, I believe we have to ask on the record, and this is, I guess, just formality as after what Mr. Abbott just said, but I would just make an on the record inquiry of the defendant whether they will voluntarily submit, and in this case, continue to submit to mental health treatment with CMH. Okay. All right. And I guess with that, just to explain, that way the prosecutor's office can then follow, and there would be no motion at this time for civil commitment. However, if the treatment were to cease, then the people would be able to a motion for a civil commitment at that time.
All right, so what about so are you dismissing the case at this time?
I don't believe we're dismissing the case.
So, I mean, I don't have a plea on this case. Is there anything been done on this? Has all been waiting for the competency review, and I don't believe she can if she's awaiting.
Right.
So I can't just keep the case open. Mr. Abbott, your opinion on this?
I asked the court to dismiss the case. We do have the possession of meth case still pending, and so as far as she remains under the jurisdiction of the court, under the supervision of the court. It's a 10-year compared to the 2-year that's disappearing.
Right.
I asked the court to dismiss it. She does continue, as I mentioned, to participate with CMH here in town. And
Mr. Brodowitz, here's my problem. This was arraigned on August 30th, 2022, and the case cannot go forward because we don't have a report, and they're not going to have a report in time. And so I'm uncertain concerning. So do the people take a stance on this file?
I guess at that point, I don't believe that people would be asking to dismiss it at this time, but I would leave it then to the court's discretion.
Right. So the court on its own, because of the report will not be done in a time period that statute requires. The people will move to dismiss this case. The court will grant defendant's motion to dismiss this file because the forensic review report.
Your Honor, I believe it's actually due to the fact that the restoration treatment cannot be completed.
Restoration of treatment will not be able to be completed. And I will write on the order that the case is dismissed upon defendant's request. The restoration time period will lapse. Before restoration is able to occur. All right, so pursuant to, and I will await, I did see the letter. We have not received the letter for whatever reason, but Mr. Abbott, I had the opportunity to review your copy of the letter. And so based on the defendant's motion to dismiss because a restoration period will lapse prior to restoration being able to be restored, Ms. O'Reilly, you're still on probation, you're still under jurisdiction of the court, but this file is dismissed without prejudice, okay? All right. So I'm going to move that over here, and then let's go on the second file, which it appears is still has time, right?
Yes, sir.
Yeah. So we're on the record, docket 2203192. And it's my understanding that on this file, that restoration is still in the process, and there's more time on this file. Is that your understanding, Mr. Brodowitz?
Yes, it is, Your Honor.
All right. So what I'm going to do is we will set this out for another date, another control date. So awaiting restoration report. And we'll set this out 30 days. I don't know. What did we do on the last one? 30? Yeah. So we'll set it out 30 days for a review. So July 28th,
20.
July 20th at 8:30.
Your Honor, I should note for the court that her mental health is substantially better than it was when it first started. I mean, she sat out in that hallway full of people expressing their emotions and yelling and running around, which when I first met her would have been an overwhelming experience. And today, so it may well be that the treatment she's receiving at CMH will bring her to a point where we can have her found competent.
All right.
Without sending her anywhere.
All right. And so this is what I'd like to do in regards to, so we're going to set it for a review on July 28th at 8:30. I would like to also, so I believe, Mr. Abbott, there's an indication that on 3 dates that there was a testing of drugs or THC that Miss O'Reilly tested positive for.
I have been consistently testing positive.
Okay. And so what I'd like to do is address that. I'd like to address that, but I'd like to have the probation officer come, and so we can sit down and see what our options are. All right. In that regard. Let's set it for that same date. Okay. So let's set it for that July 28th date. July 20th. I keep on saying the 28th. Yeah, and let's set it. We'll set it for. I don't know if you want to call it a probation violation or probation review.
It's pretrial services.
Okay, a pretrial services review. Trial review is also set for July 20th at 8:30. Ms. O'Reilly, there's no doubt whatever they're doing is working on some level. I mean, we can see that, you can see that, but I'd like to go through and make sure that we're all on the same page concerning some of these measures in this memorandum that your attorney has not seen. Okay, so we're going to set it all for that 28th date. We're all going to meet up and we'll try to figure it out. Okay. All right. In the meantime, you're still under pretrial orders, so understand that. All right. So we'll set it for that July 28th date at July 20th date at 8:30. Thank you, Mr. Abbott. And then I will have at least the memorandum. I'll have you look at it. Anything else for the record in docket 2203192, Mr. Brodowitz?
Nothing from the people.
Mr. Abbott? All right, thank you. You can provide a copy of that to Mr. Abbott. Okay.
And just for the, since we're off the record, Your Honor, you said that I think it's 22-00388 FY, People v. Williams would be this afternoon.
Yes. Well,
we're ready to go right now, Your Honor.
Yeah. Is that Anthony Williams?
No,
Michael.
Okay, that's the problem. We had 2 Williams. So I have a Michael Williams. This app that's set for 9:30, and I have a Anthony Williams that's set for 8:30. One is my case and one is Judge Simmons' case, and so we're ready on my case, right, Michael Williams?
Well, I think we have a couple other really quick preliminary matters to take care of. If you could, Your Honor, we have.
Is that going to be a hearing?
That one, I believe, is going to be a hearing. Yes.
Okay.
Yeah, Williams.
All right, so So let's see what else we can move before we start that. Okay. That's Michael Williams.
Right.
Your Honor, we are ready to do a preliminary exam waiver on Kelsey Kalazuk's case.
Kelsey Kalazuk.
Your case scheduled at 9:30.
Okay.
You know,
Kelsey,
for 3 judges, we got it almost all done before noon.
yeah, let's not do this all the time, but
Sorry.
but we are getting some things done. All right, that's Miss Kalazuk. Okay. All right. And Mr. Goodrich, I still have an order of fingerprints. So in the file, have you been able to get fingerprints, ma'am?
No.
All right, you probably should go today or as soon as you can and get fingerprints regardless of what happens, all right? And we'll make sure you have an order for that. All right. Let me see there. No, we are on, yes, we're on our docket. Yeah, this is Kalazuk. All right, so we're on the record in docket 22-01678. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office here to represent Ms. Kalazuk, who's standing to my right.
And ma'am, you are Kelsey Kalazuk?
Correct.
Okay, this is the time set for a preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, after discussions with the defense, I believe the defendant will be unconditionally waiving their preliminary exam. So with that, the people would also unconditionally waive their preliminary exam. And we would move that this be bound over to the circuit court as charged in the complaint. And just for the record, I know it's probably on there from last time, but the people have made an offer of drug court in this matter, and that offer would remain open up the circuit court.
All right. So is that your understanding, Mr. Goodrich? Your client is going to waive their right to a preliminary examination. Negotiations are continuing, and there have been some drug court negotiations.
Yes, and I just let the court know there's a file in East Lansing that is an actual drug case at this point, and there were negotiations to resolve both matters.
Yes.
All right. May I inquire your client of her waiver of the preliminary examination?
Yes, sir.
All right. Ms. Kalazuk, you understand you have a right to a preliminary examination within 21 days of your date of arraignment.
Yes, sir.
Preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove in this file that a crime has been committed and the identity of the person who committed that crime. Do you understand that, ma'am?
Yes, sir.
You, of course, are represented by attorney Luke Goodrich, and he would be present to cross-examine any witness and contest any charges brought against you in that preliminary examination. Do you understand that? All right. It's my understanding that you wish to waive your right to a preliminary examination and have this case bound over as charged. Negotiations are to continue, and there have been drug court negotiations along with this file. Is that your understanding?
Yes, sir.
All right. Is it your wish today to waive your right to a preliminary examination in district court today?
Yes.
Do the people also waive their right to a preliminary examination?
We do, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will bind over as charged these counts to circuit court. Please, Ms. Kalazuk, please keep in contact with your attorney, Mr. Goodrich. Your next date will be in circuit court, and your time in district court will be done, and I'll have you sign the circuit court bind over, okay?
Okay.
All right. There you go, Daniel. And then, I don't know if you want to make a copy. This is the order for the fingerprints that should be done as soon as possible. Sure. Okay. Yeah, we can figure out what's left. Yeah.
Your Honor, are we all set? on
You
the
should be
schedule?
all set, yes.
Okay,
Thank you. All right, we're gonna take a 5-minute break. I'm just gonna figure out where we are and we'll adjourn for that.
I'll be right back. Your Honor.
Okay.
Zach Johnson got brought over today.
Yeah, he should be done.
Okay. I wanted to-
So I still have on my list of Nathaniel, we have Mr. Williams going, that's Abbott's, right?
Yes.
And Mr. Johnson, that's the one that's been brought over, right?
Yes.
Okay. So those are those two. Then I have on Judge Simmons, I have Williams, Jeske, and Lewis.
Yeah. Williams is gonna be in the afternoon.
Okay, Williams is in the afternoon.
Jeske's here right now in the courtroom.
Okay.
And see Lewis.
How about Cockrum?
FTA.
FDA? Okay. So let's see if we can move some of these Judge Simmons files. That's Mr. Cartwright, right?
Nick said that Cockrum was here.
What's that?
Nick said Cockrum was here, but he doesn't know where he went.
Mr. Milk's gonna address that. So Anthony Williams is this afternoon.
Yes.
So we're looking for Cartwright and Milks. Those are our guys. Those are our peeps.
Oaks was done with Buchanan.
All right. We might start Mr. Abbott's prelim here. Doesn't look like anything's ready to go before yours.
Good.
What's that?
Good.
Good. That's right. Good. on the record in docket 22-01976. That's People of the State of Michigan versus Jonathan Jeske. Will the parties please introduce themselves for the record?
Thank you, Hunter Dale Coltrane, on behalf of the people.
And good morning or good afternoon, Your Honor. Stephen Milks on behalf of Mr. Jeske, who is present and standing to my left.
And sir, you are Jonathan Jeske?
Correct, Your Honor.
All right. This is the time set for a probable cause conference. Mr. Colwright, how are we proceeding?
Your Honor, it's my understanding at this time that the defendant will be entering a plea to an amended count 2, and that would be use of methamphetamine. That is a 1-year, $2,000. Finding successful entering of that plea, people would then dismiss count 1, which is the possession of methamphetamine.
Use.
And I do have the statutory number.
And what's the statute for that?
For the use is 333-7404.
Say it again, sir.
Yes.
I didn't hear the 333-74.
333-7404 A2, I believe.
A2.
Or 2A, I'm sorry.
2A. All right, and with a successful plea to count 2, the added count 2. Added count 2, count 1 is to be dismissed. So I will reiterate that plea, the negotiations for Mr. Milk, and then make any corrections. We're going to add a count 2 of use of methamphetamine pursuant to 333.74042A. That's a 1-year and/or $2,000 fine. With a plea to count, with that plea to count 2, count 1 is to be dismissed.
Your Honor, that is a complete and accurate statement. We also wanted to make the court aware that he had pending cases in both Eden and Clinton. He has since been sentenced on those and is to serve probationary period as well as going to inpatient treatment. The only thing holding him back, I believe, is this matter here.
Okay, all right. So, oh, I see this kind of research. All right. So is Mr. Jeske, is that your understanding of the plea agreement? A plea to the use of the 1-year use and dismiss the possession of methamphetamine.
Okay.
All right. It's my understanding, sir, that you've signed an advice of rights indicating that you understand your rights in the misdemeanor case and that you're going to waive your rights to plead guilty today. Is that correct?
Yes, Your Honor.
That's just the 3 quick rights that I'll cover. The highlight: you understand you have the right to trial by jury in this case. You have the right to a court-appointed attorney. You of course are represented by attorney Stephen Milks, and he would be present to contest any charges or cross-examine any witnesses at trial for you. You understand that?
Yes, Your Honor.
You also have the right to remain silent. Your silence can't be used against you in a trial. Do you understand that?
Yes, Your Honor.
All right, with that understanding, I'm going to have you raise your right hand as best you can. It's my understanding you wish to waive your rights and plead guilty today. Is that correct?
Yes, Your Honor.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Okay, I'm going to bring your attention back to March 12th of 2022 at the offense location of Hillsdale in the Walnut Street, city of Lansing, Ingham County. On March 12th, 2022, were you at the Hillsdale Walnut Street address in the city of Lansing, Ingham County?
Yes, Your Honor.
Okay, and at that time, did you use methamphetamine at that date and time?
Yes, Your Honor.
All right. Anything towards the factual basis, Mr. Milks?
No, Your Honor, not towards factual basis. Thank you.
All right. Anything towards the factual basis, Mr. Coltwrighter?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. Mr. Milks, would you like to be heard on sentencing? My reaction here is to refer to probation, but I'm uncertain about the different variations here.
Thank you, Your Honor. Your Honor, we would ask that the court consider sentencing him today, if that's what the court's asking right now. He had some big cases, big charges in Eaton and Clinton, as well as here. He is on probation, or was sentenced to probation, and Mr. Coltwrighter has also confirmed that with me, as well as my client confirming that with me. And my client is seeking treatment. This is a great opportunity for him. He has served jail time, I know, there, as well as waiting on this case here. And I think we're past the point of any sort of punishment. Definitely time to get him to treatment. If we can sentence him here today, Your Honor, It's my understanding he will be released to inpatient treatment. So that's what we're truly hoping for here, so he can get the start on his next leg of the journey.
Mr. Callwriter.
Your Honor, I'm going to defer to you on this. I think treatment is always a good thing. I would indicate it is true. We did confirm that he is on probation with Clinton County. Looks like he was just sentenced in Eaton County. I believe he has a PR bond on this, so he could go to treatment anyway.
Right. He'd be able to go on a PR bond to treatment on this case. I just want to know where the case lays here. I understand. I do think treatment is probably the most preferable mode here, but I need to know where all the other cases lie. So I'm going to refer to probation. Probation should contact you. Really, the pre-sentence report is, I understand treatment is a measure for you. I just want to find out everything about what's going on. So if we can order anything that will be a benefit to you, that's what I'm going to do. Okay. I see this as a case in which treatment is the optimum goal here. I just want to make sure it's the right treatment and you get to the right place. Okay.
Okay.
So I'm going to refer to probation for pre-sentence. And he's currently in Eaton County? Clinton County.
He's currently in Clinton. My understanding is that he's not going to be able to be released, I guess, which makes sense since he's still in Clinton. And we got a PR bond here. He's not going to be able to be released to treatment until this matter's cleaned up according to his PO in Clinton.
Yeah, they said they don't want to send me to TRICAP, which is like an institution type treatment
Right.
until everything's resolved.
All
So
right.
I can't go back to court.
Okay, so let's at least get probation involved and make sure that we get a date that you can get you there. Because I'm pretty sure that would be our probation's idea, was to get you, if you're already accepted a TRICAP, you have a bed, let's get you there. I'm going to indicate that held on file until Clinton County. Yes. Right. So I'm going to indicate that they should see you ASAP. And then we'll set a sentencing date. And then we can move that around depending on where you're getting treated. It'll be in front of Judge Simmons. That's, yep, so. All right. So sir, I won't be doing the sentencing. Judge Simmons will be doing the sentencing. I've just left the notes. Or Mr. Milks, I can take over the sentencing if you want me to.
It doesn't matter to me,
Okay.
Your Honor. Yeah, I just, if we can have the most immediate sentencing day, I know that's asking quite a bit, but.
Yeah, I don't, let's see, they have their sentencing dates are set for August 10th, 2023. But if this works correctly, I think the defendant will be seen, will go off to rehab, and then that sentencing date is somewhat flexible with the understanding that maybe he can zoom in for sentencing or something along those lines.
I think that's what his probation officer was saying in Clinton County, is that they just want everything cleared up because he can't be taken back and forth to TRICAP. I don't know if TRICAP does. If it was Bear River, I know they definitely do.
Right, a Zoom, something Zoom.
TRICAP, I don't.
All right.
I'm sorry.
Well, we'll definitely work with that schedule. Let me talk to Judge Simmons about it, okay?
Okay.
All right. But we have August 10th is the date right now, 2023, at 9:30 for sentencing. But there's a reason to expedite this if the rehabilitation center is waiting on him. All right. Anything else? So what's paramount is to get him to TRICAP. I think everybody's on the same page there. And I'll indicate that for the record, that on the file.
I know the court can comment on this, but will the court consider sentencing him today possibly?
I just don't know enough about what else is out there, you know. So I understand the request. I'm going to deny it at this time and wait to see all the reports. but we'll see it as soon as possible. So Judge Simmons. And Mr. Milks, if our probation department decides that that's the best course of action, we might just reset it. Okay. All right. All right. Anything else for the record docket 22-01976, Mr. Callwriter?
No, Your Honor.
Mr. Milks?
No, thanks, sir.
All right, Mr. Jeske, you're all set today. Then we have Mr. Callwriter. Do we have a Mr. Lewis?
Yes, that is being left on, Your
Okay,
Honor.
so
I
Mr.
understand he was on video earlier.
Okay.
That was supposed to be a waiver because Judge Simmons isn't here, but I guess we'll just do it.
All right, so let's leave that on.
And just, I know that there was a motion, I guess not a motion, but a request from Judge Simmons that these cases, there was good cause to adjourn them. You are not doing that. That will be left out for next week.
Yeah, I'm just gonna leave it on and we can adjourn it that matter. I mean, it's just with 3 other judges here, it's hard for me to say that there's good cause to adjourn when it'll be easy to handle, on some level. So, all right, so Mr. Lewis is left on for next week at his PCC. And how about Mr. Cochran?
Your Honor, it's my understanding that will be left out for next week.
All
Mr.
right.
Cochran was here in the courtroom earlier. I did see him. I have conveyed an offer of misdemeanor on that to counsel. I believe it will be our office's intent at this time, probably to amend that charge to a misdemeanor.
Okay. 6:23 at 9:30 and wait a minute. All right, so we'll leave that on for next week and then we can deal with that accordingly. Are you?
A pleasure.
You have Mr. Williams this afternoon, right?
I do not.
Okay. Oh, he doesn't have any, but I have Anthony Williams set for this afternoon.
That would be Miss House.
Okay, Miss Housefield. All right. You're all set, Mr. Callwriter. Thank you.
Thank you, Your Honor.
That's Mr. Anthony Williams. And then let's do Mr. Michael Williams.
Right.
And we'll track down Mr. Brodowitz. And then Mr. Goodrich, you had Johnson too, right?
Yes.
Okay.
That is a plea.
Okay. So we'll do that once we get Mr. Williams.
Go. Yes, it's gonna be. Okay.
All right, so we're on the record in docket 22-00388. That is People of the State of Michigan versus Michael Lynn Williams. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
John Abbott representing Michael Williams. He's standing to my right, Your Honor.
And sir, you are Michael Lynn Williams?
That's right.
Okay. This is the time set for a preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. Conversations with the defense. I believe we are running a preliminary examination.
Okay. Are there any preliminary matters to come to the court's attention before we get started, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right. I do see Mr. Goodrich is in here. There's one witness in here who I think is probably your first witness.
Yes.
Okay. Mr. Abbott, any preliminary matters to come to the court's attention?
No, thank you.
All right. With that understanding, Mr. Williams, you can have a seat. And Mr. Brodowitz, you may call your first witness.
Yes, Your Honor, at this time, the people call Officer Trevor Allman.
Officer, I'm going to have you stand right in front of me. Please state your first name and your last name and spell them both.
First name Trevor Allman, last name, or first name Trevor, last name Allman, first name Trevor, last name Allman, Allman.
Perfect. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, please have a seat here. The microphone is right in front of you. That's for the recorder. But if you project to the back of the room, everybody should be able to hear you. Okay, sir? Mr. Brodowitz, when you're ready.
All right. At this point, good afternoon, Officer Allman. Officer, how are you employed?
Work for the City of Lansing Police Department.
All right. And how long have you been a police officer with the City of Lansing?
5 years.
All right. And what's your current position with the Lansing Police Department?
My current position is a community police officer on patrol.
Okay. And were you working in that capacity on January 3rd, 2022?
At that time, I was a regular patrol officer.
Okay. So were you working in the capacity as an officer for Lansing Police Department on January 3rd, 2022?
Yes.
Okay. And on that date, how were you dressed?
In full police uniform.
All right. And did there come a time when your duties took you to 3200 South Washington?
Yes.
Okay. And is that located in the city of Lansing, Ingham County?
Yes.
All right. And why were you dispatched to that location?
Dispatched for a harassment complaint, call for service.
Okay. And when you arrived at that location, did you make contact with anyone?
Yes.
Who did you make contact with?
Janisha Davis, I believe that's how you pronounce her first name.
Okay. And when you arrived there, can you describe her demeanor for the court?
She was crying during my contact with her.
All right. Anything else of note?
No.
Okay. Was anyone, when you arrived, was anyone injured on scene?
No.
And what, when you arrived on scene, did you, what I guess when you arrived on scene were you informed of by Miss Davis?
Reynolds, I object. It's hearsay.
Response?
I'm just trying to show its effect on the listener, Your Honor, not for anything substantive as to how he proceeded.
All right. Is this your only witness in the case, or do you have another witness?
I would be asking for a continuation, Your Honor, specifically for identity purposes, but this would be my only witness today.
So my understanding, you're not offering these statements under 768.27C?
I will be making that motion, Your Honor.
All right. Well, there's certain criteria that you have to meet in order to make that motion.
Yes, I'm aware, Your Honor.
And so, yeah, so my understanding is that statement purports to narrate, describe, or explain. But if you are laying foundation for that motion, then I'll allow you to proceed.
Yes, Your Honor.
All
That's
right.
the purpose.
But I don't want to get into the facts of the case. I just want to know that the foundation is laid for that 768.27C.
Yes, that's.
All right, Mr. Abbott, you're based on foundation for that statute. I'm going to overrule your hearsay objection at this time, but I'll entertain more hearsay objections as we go forward.
Thank you.
So when, without saying anything, so you said you were dispatched for a harassment complaint. Was that ever expounded on when you arrived on scene?
I'm sorry, expounded.
Was it ever expanded on? Was there ever more detail provided by Ms. Davis?
So through my speaking with her, I learned that a domestic assault had been reporting a domestic assault.
Okay. And did she say who this was between, or who the other party was in this domestic assault?
Yes.
And did you obtain any information about the relationship between Miss Davis and the other party in this assault?
Yes,
Okay, and what was that relationship?
she had told me that they had previously dated and they shared a child in common.
Okay. And then, so you stated previously that nobody was injured on scene. So without telling me what Miss Davis said, did she describe or explain to you how she was assaulted?
Yes,
Okay. And did you learn when that assault took place?
yes.
And when was that?
She told me the night before at around 10 o'clock. Yeah.
Okay. Just one second, Your Honor. At this time, Your Honor, people would seek to admit the statements from the victim to this officer pursuant to 768.27C. In that, I believe all 5 requirements under the statute have been met. One, that this statement was about a physical injury or the threat of physical injury, indicating that the victim indicated there was an assault in this matter, that it was made at or near the time of infliction, that this was the night before Officer Allman responded, that it was involving a domestic violence incident. As we heard through the testimony, they shared a child in common. They had a former dating relationship. The circumstances in this case would indicate trustworthiness based on the victim's demeanor in this case, and that the statements were made to a uniformed police officer.
Okay, any response to the people's intent to use hearsay statements pursuant to 768.27C?
Other than the due process argument, Your Honor, that it's just unfair to use hearsay against a defendant, and if the case gets bound over, it'll languish in the 30th Circuit for months without anybody having testified as to what actually happened based on personal knowledge. He did say the words domestic violence and child in common, so I'm afraid, other than that, he's met the statutory proofs, Your Honor.
Thank you. I'm well aware of the confrontation argument and theory in this case. I did not create or legislate 768.27C. It does have confrontational problems as far as I can tell as it relates to the confrontation clause, but for our purposes, the foundation has been met on 768.27C, and Mr. Brodowitz, you may proceed with the hearsay statements in regards to the officer.
All right. So Officer Allman, what did Miss Davis say happened to her that day?
She explained the night before her child's father, Michael, had come over to see the kid that they share in common. And during that time they were together, there was conversation about how they shouldn't be having a sexual relationship anymore, or a relationship at all anymore. At that point in time, Janisha Davis told me Michael appeared to be upset, started putting his shoes on to leave while she was telling him to say goodbye to their kid. And she proceeded to tell me they talked about their relationship for quite some time, in which Miss Davis told Michael that she had wished his mother raised him better, and that upset him because she had told me that his mother had passed away. At that point in time, Miss Davis told me he pulled out a black gun, unknown from where, held it at his side, and threw a plastic water bottle at her. Some of the water ended up getting on her leg, in which she responded to that with throwing her plastic water at him, and the water bottle ended up hitting his chest area. At that point in time, she told me Michael raised the gun toward her and said something along the lines of, "I know what I'll do," and then proceeded to leave the apartment.
Okay. And did Miss after this, did Miss Davis tell you if she felt that, I guess I should say, who, you kind of already mentioned the name, but who did Miss Davis say did this to? Did this to her?
Michael Williams.
Okay, and did she ever tell you if she was, if she feared if Mr. Williams would actually use the firearm?
She said she kind of thought he would use it.
Okay. And then after hearing the statements from Ms. Davis and making your observations, what did you do after that?
I did note that there was something on the interior side of the entry door that appeared to be running down the door. I'm not sure if it was the water involved or not, but I observed that. And I had began the process of writing a police report for her and getting those resources.
All right. And did you ever come into contact with Mr. Williams?
No.
Okay. And all of this happened again, just to clarify, all of this happened at the address of 3200 South Washington?
Yes.
Okay. No further questions at this time.
Cross-examination, Mr. Abbott.
Thank you. Good afternoon. So you arrived some time after this alleged event occurred?
Yes.
And so you don't really have any personal knowledge of when he arrived? Or when he departed? Or whether he was actually there at all? And you can't identify whether or not this is the person she was talking about?
Correct, I cannot.
And I noted in your police report, it said you took no photographs because there was no injury.
I didn't take any photographs of Janisha, no.
You didn't see any injury on her? Okay. And as far as a firearm, you didn't locate a firearm? And no ammunition? No. And no spent cartridges? No. And there was no fingerprints taken?
No.
And no, so there's no DNA sample or hair sample? No physical evidence that he was ever there?
No.
Thank you. Nothing further from this witness.
Any redirect, Mr. Rodowitz?
No redirect, Your Honor.
May this witness be excused from the people?
Yes, Your Honor.
Mr. Abbott?
Yes.
All right, thank you for your appearance today. You're excused. Mr. Brodowitz, any further witnesses?
Nothing today, Your Honor. However, as I indicated, the people would be asking for a continuation a brief continuation in this matter. I think 1 week would suffice, just so that we can subpoena one witness in order to make identification in this matter, and then move for bind over.
Mr. Abbott, any response?
We object completely, Your Honor, to this adjournment. The victim herself didn't show up today, the alleged victim. Mr. Williams has been here all morning waiting for his preliminary exam, which he has a right to have within, days of his arraignment. This is a crime that allegedly happened in January, so they've had plenty of time to get ready. They knew when this hearing was, and it doesn't sound like there's anybody besides the alleged victim that was present at the time they could identify Mr. Williams as the person who was there. So I think it's unlikely that they'll be able to proceed. I'd ask the court to dismiss the case, since there's really no likelihood that they're going to be able to identify my client as a person who was at that house at that time, without Tanisha, and she's not coming.
Thank you. Mr. Rodowitz, response?
Yes, Your Honor. In regards to the objection to the continuation, the people have established through the 76827C testimony of Officer Allman, all of the, I believe at least -1 as to count 2, of which I will be providing as well if the continuation is granted. And that would be the felon in possession. That would be a certified record of conviction, that the people have satisfied all elements for the charges and for bind over outside of identity. Just so the court would be aware, the people would be seeking to subpoena the officer who arrested Mr. Williams on this charge in order to make an identification and then move for bind over.
All right, so the request, the defendant has right to preliminary examination within 21 days of his date of arraignment. The preliminary examination has started in regards to Mr. Allman testifying. I'll grant the adjournment for brief adjournment for continued proofs concerning this preliminary examination, and we'll adjourn to the next possible date. You'll need about a week's notice, right, Mr. Brodowitz?
I believe a week should be sufficient, Your Honor.
So.
And
So June 22nd at 9 o'clock, Mr. Abbott, you might want to check your trial schedule.
It's next
Thursday. Next Thursday.
I got a feeling I'm gonna be here.
Okay, so, all right, so we will recontinue this preliminary examination to June 22nd at 9 o'clock. Anything else for the record, docket 22-00388, Mr. Brodowitz?
Nothing from the people.
Mr. Abbott?
Nothing for the defense.
All right, Mr. Williams, we'll see you next week at 8:30.
9, I think. Your Honor.
Oh, did I? Let's see. 9 o'clock.
I'm all right to go.
You're all set, sir. Thank you. But we have a notice for you just in case, so that you have it in writing. We're gonna take a break. But, well, we have Mr. Is he on, or do you have to go get him?
He's downstairs.
All right.
He's in custody.
All right, so I'm Mr. Goodrich, you probably want to have lunch too, but we can wait till to set him for the 1:30s and go get him, or we can get him right now. It's up to you.
I guess I'd rather do it now because I have Judge J-Mo too.
Okay, so let's go get him, and we'll just grab me when you're ready. All right.
Okay.
all right.
Oh.
Hey, I think he's doing pretty impressive. It's gone very well. Yeah, that in like 4 hours, he did 3 dockets. That's
Yeah, my client was crouching.
got an airplane. That's a problem.
He did start snoring there.
Goes off after that again too. It's funny. The one time, like he was like they're like sleeping. You were also in kind of like the similar pose, and we're pretty sure that's his client.
I was reading my notes. Sure you
Okay. I'm not going anywhere. I got something to say.
You have Aaron Conley? Is that? No,
yeah.
this is it's Key One Eskin, Duvall Gaskin, and Sergeant Wayway. I don't know if that's how you say his last name. W-A-W-A-Y.
I know Keith Eskin's got stuff.
What?
I know Keith Eskin's got stuff. Oh.
Yeah, Barry's got Eskin, Dick Carter's got Gaskin, and I don't know who's got Wayway. What's his name? Oh no, that one. I plan on yeah. Okay. I think I'm gonna be asking for an adjournment on that one because the third code, same thing with Conley, the third co-defendant just got a rate. And so
Is Conley adjourned then today, or?
yeah, that got adjourned today.
Who's his attorney?
Conley's got Kareem Jackson or
Oh,
something out of Jackson County.
So, yeah. We got figure out. Is that gonna, what happened to the adjournment though?
Yeah, they adjourned all because there's like
That guy ain't waving shit.
no.
That's gonna.
Because I'll tell like
Is that your case?
It
technically is, but Andrew's handling it. I think just because of the complexity and the people involved. I haven't been around this area. I mean, I went to school with MSU for 8 years, but I haven't been in the Lansing area all that long. But I've heard that the Conleys are regulars in the legal system.
Well, Aaron, I believe, had been in prison most of the last
Yeah,
decade.
yeah, he's so, but Ben Jr., Ben Senior.
My office had to bail on that case complete.
Yeah.
Because like the victims are.
Yeah, so they.
I'm
I
amazed
don't
that a
know, I
victim
don't know if
didn't
you
end up
read
dead.
that. I don't know if you read that.
I've
case.
heard the facts being told to me.
Yeah, it is a complete mess. And they're slowly finding everybody involved. So.
I'm here every week pissed off at that exam.
Yeah.
This is not gonna end
I don't even know how they're gonna do that. They may have to take board support. I don't know how you're gonna fit 5 defendants out here.
You're right. They are gonna take.
Yeah.
Yeah. So there's 5 defendants now?
I think so, because you have Conley with the original incident. And then parsed off that original incident is the woman who just got arrested and arraigned. Julia Hartwig, I think is her name. And then you have Beck, so maybe there's only 4 actually. Then you have Beck and his girlfriend who are also involved due to witness tampering charges.
Are you getting a witness here for that?
Yeah. I've been in contact with them both times I've called them. I've been in contact with them. They're game for it. Which honestly, I am a little surprised about based on the facts. But
Yeah, but I guess it's, you think about it, the as long as he stays involved, he's going to remain behind bars.
yeah. So
His own personal safety is going to decline if the case moves forward.
hey, that's so
Trying to see where everybody went. Nick.
we actually had Aaron talk, I'll let you know on that receiving and concealing. The woman whose car it was did show up. I think though, if I'm not mistaken, and this is, number one, we didn't subpoena her. So I didn't think we needed her. Well, whoever did our witness list, I think thought we needed them for the receiving and concealing part, but if I'm not mistaken, if it's the person who did it, she was sitting down on one of those benches there, chatting with Remington.
Remington knows.
Yeah, and that's why I'm like, I didn't think that was the victim, because she's chatting with one of the defendants. So I didn't even bother to, or no.
Lost his tools.
Maybe next time we get a few or something, take it to the Secretary of State and check and make sure it's not stolen. Whether you move it or not, doesn't matter at this point. Yeah.
Okay.
All right.
Right.
Coming in.
Have a seat, Mr. Johnson.
I'll be right out.
All right, so we're on the record in docket 23-01549. That is people of the state of Michigan versus Zachary Johnson. Will the parties please introduce themselves for the record?
Jeff Reynolds on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Johnson.
And sir, you are Zachary Johnson?
Yes, Your Honor.
All right, this is the time set for a preliminary examination on the matter. Set for plea and preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, after conversations with the defense, I believe we have come to a plea on this matter. And that would be from the defendant, Mr. Johnson, to plead to, I believe it would be an added count 4 use of methamphetamine and an added count 5 attempted resisting and obstructing police officer. And upon successful plea, people would seek to dismiss counts 1 through 3.
All right, and the code for use of methamphetamine? That's a 1 year and or 2000, if I remember correctly.
So the PAC code on that is, I believe, 333.74042A and then -A.
Okay, and then on attempt, it's also the attempt RNO is a 1 year and or 1000. And I think that is the same PAC code with an A, right? 750.81D, parents 1A.
I believe so.
All right, so I'll restate that for the record. This would be an added counts 3 and 4. Okay, I see that's 4. That's 3. Okay.
4 and 5.
So it'd be 4 and 5. Okay. So added counts 4 and 5. I'll restate for the record. The defendant's going to plead guilty to count 4, use of methamphetamine, that being a 1 year misdemeanor and or $2,000, pursuant to 333.74042A-A, and count 5, attempted resisting and obstructing, pursuant, that's 1 year and or $1,000. And that is pursuant to 750.81D, parents 1, parents A, with a plea to counts 4 and 5. Counts 1, 2, 3, 1, 2, and 3 are to be dismissed. Is that your understanding, Mr. Goodrich?
Yes, Your Honor.
All right. May I inquire of your client of his advice of rights?
Yes, Your Honor.
Concerning his misdemeanor plea. Sir, you have the following misdemeanor rights in this case, and I'll walk you through those. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by attorney Luke Goodrich. He would be available to cross-examine any witness and contest any charges if we went to trial. You'd have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim that the plea was a result of any promises other than what's been stated on the record in the plea agreement or threats that it was not your choice to plead guilty. You'll also be giving up any appellate rights because you won't be having a trial. You'll be pleading guilty today. Is it your intent to plead guilty today, sir? Okay. And so I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, I'm going to bring your attention back to May 19th, 2023 at 500 East Saginaw Street, City of Lansing. Were you at 500 East Saginaw Street in the City of Lansing on May 19th, 2023? Okay. And at that time, did you use methamphetamine?
Yes, Your Honor.
All right. And at that time, did you assault, batter, wound, resist, obstruct, oppose, or attempt to do something along those lines to officers Brown or Kurtz in the Lansing Police Department?
No, Your Honor.
You did not do any you did not attempt to did they give you an order, sir?
Told me to leave the property.
Okay, and did you leave the property?
Oh, yes.
Okay.
At some point, did they order you to stop?
Yes, Your Honor.
Okay, and at this and it's my understanding, as an attempt charge, you did not attempt to stop, or you did not stop.
Yes, Your Honor.
All right. Anything towards a factual basis, Mr. Brodowitz?
Nothing from the people. Your
Mr.
Honor.
Goodrich?
Nothing, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made into counts 4 and 5. Counts 1, 2, and 3 are dismissed as a part of the agreement. And we will refer to probation. Mr. Johnson. So Mr. Johnson will be contacted by the probation department while he's incarcerated, and we'll get a sentencing date. Mr. Johnson, just answer probation's questions, and they'll provide the court with some options so we can look at sentencing. Okay, sir?
Sure.
All right. We have a sentencing date of
With August 10th at 8:30 with Mr. Goodrich's schedule.
August 10th at 8:30.
Yes.
All right. So we'll set sentencing for August 10th at 8:30, and probation will be in contact with you, sir. Okay?
Your Honor, could we possibly address bond, maybe even after probation were to meet with him? He's currently, I believe, has a 3,010% bond. If he was to be released, he would go to the shelter at 430 North Larch. I know he has a CMH caseworker who was here last week that he'll get in contact with. We would ask the court to consider maybe having this convert to a PR bond after getting interviewed by the probation department.
Mr. Brodowitz.
I guess with that, Your Honor, the people would have no problem readdressing bond after probation has met with Mr. Johnson, and then can provide their input as to what bond should be set.
All right, well, let's do this. Let's get Mr. Johnson met with by probation, and then I'll re-entertain a motion to reduce bond at that time, and we'll readdress it at that time. PR bond might be appropriate then for the placement, but we'll address that at a motion to reduce bond after Mr. Johnson seen by probation. Anything else for the record, docket 23-01549, Mr. Brodowitz?
Nothing from the people.
Mr. Goodrich?
No, Your Honor.
All right, Mr. Johnson, you're all set.
When am I going to see probation?
As soon as they're down to get to see you, hopefully within the next 48 hours.
Thank you.
Okay, thank you. Yeah, there are.
Is it
What's that?
by chance MPOC?
It's SLF hearings.
Yes,
Yeah.
and
Oh, you have
yes.
it.
And Aaron Housefield.
Perfect.
1:15.
I have 15 minutes for lunch.
All right.
I will,
Good luck with that.
all right, thanks. I'll be back in like 40 minutes here.
So, Mr. Brodowitz, you've got
2 o'clock.
Eskin and Gaskin.
Yes.
All right.
To give you a brief heads up, Your Honor, I plan to ask for an adjournment in that one.
Right. That's my understanding. I would anticipate some objections to that.
I anticipate, I will say this, I've spoken with, I won't name names, I've spoken with one of the attorneys over the phone, and I've received an email from one. I expect an objection from one of the attorneys, but not the other.
All right. All right. So we'll wait to hear from that. I think we have Mr. Williams as another. Did you need me for something?
I just had a quick question
Sure.
for you on Mr. Jeske.
Yes.
Jonathan Jeske. Are you gonna be okay with a verbal PSI? I met with him, did my kind of assessment
Right.
kind of thing. Are you okay
I'm fine
doing
with
that
that.
verbally?
Yeah.
Okay.
Yeah.
Then I'm prepared whenever.
All right. So 2-ish, I bet.
2?
Yeah, don't you think? That 2:15 should be.
Yeah.
I mean, you can just email me whenever you're ready.
Yeah,
for
why
me.
don't we do that?
I'll email you. Would you prefer email or Teams?
Email's fine.
Okay.
Yeah.
We have an MDOC, we have a committee, and we're trying to
Sure.
finagle in a civil matter.
Sure.
But we should have some time, so we'll just kind of
My
find a place to
understanding is
email.
I'm completely available, so
And-
whenever.
Yeah, we'll have Nick bring him up. My understanding is Nick talked to the jail and they're not gonna send him back until we see him.
Yeah,
Okay.
he was in my office with security. We did
Okay.
what we
Perfect.
needed to do, the information I needed to gather, and then I just figured save everybody time if I didn't try to type something up and everything, if I just
Perfect.
verbally.
Yeah.
Okay,
All right.
I
Sounds
will
good.
email you as soon as we are ready. Thank you so much.
sounds great.
Heather.
And like I said, I'm completely open, free, so whatever time, just shoot
All
me
right.
an email and I'll be up.
Thank you, ma'am.
Yep.
Okay, so.
Eskin, Gaskin, Jeske, and Chambumba.
Okay, we can go on this guy because he doesn't have counsel.
Oh, is this
So we're just gonna
this
have to
is
make him
Williams?
Yeah.
All right.
So he does not have counsel.
This is Anthony Williams. All right, so we're on the record in docket 23-00258. That's people of the state of Michigan versus Anthony Williams. Will the parties please introduce themselves for the record?
Thank you. Good afternoon, Your Honor. Erin Housefield on behalf of the people.
And sir, you are Anthony Williams?
Yes, sir.
All right. And you can hear me all right, Mr. Williams?
Yes, sir.
All right, this is the time set for a probable cause conference. Ms. Housefield, it's my understanding, Mr. Williams, you do not have counsel today, is that correct?
Yes, sir.
All right. So at the probable cause conference, it would be the court's intention just to leave this on for preliminary examination. Ms. Housefield, what do you know about Mr. Williams getting representation in the matter?
I did have the opportunity to speak with one of the members of the Public Defender's Office this morning to determine whether he might have a request in screening. The Public Defender's Office record system shows no information about Mr. Williams. So if he has made a request through the Public Defender's Office, it has not been processed.
Mr. Williams, have you made contact with the Public Defender's Office in regards to representation in this matter?
Yes, yes, sir.
Okay.
Requested it.
And it's so is it that the application process has not gone through, or is it something a clerical error? Because I think the application was made. Is that correct, Ms. Housefield?
When I inquired of the public defender this morning, he indicated that there was no information about Mr. Anthony Williams in their system. So they don't show any
All right,
record of his case.
The court file has it that go ahead.
He requested one in arraignment. I'm sending an email to him.
All right. So my understanding is that arraignment, he requested public defender representation. And so the court's going to email the public defender's office to see if we can start the ball rolling in that regard. Okay.
Okay. It is,
All right.
this matter is currently set for preliminary examination, Your Honor, next week on the 23rd with Judge Simmons. It's my understanding that her docket that day is being changed to another day. Is that a correct understanding?
Well, I do find on this case, I would find, since we don't have an attorney today, and I don't know if we would get discover an attorney in the next week, I do find good cause to adjourn this matter because Mr. Williams does not have counsel. And so I am going to find good cause to adjourn this matter so that counsel can get the file, talk to Mr. Williams, get the discovery, and then zealously advocate for Mr. Williams in his defense. And I'm assuming that's what you want, Mr. Williams. You're not waiving any rights. I just want to give your lawyer time to look at the discovery and make sure you have enough time to be represented in this matter, okay?
Yes, sir.
Okay, so I'm not going to have you waive any rights today. I'm going to find for good cause to adjourn past the June 23rd date. June 23rd date. I'm going to indicate that D did not waive and the court found good cause. And we will reschedule for
July 13th.
July 13th at 1:30. Does that date work, Ms. Housefield?
Yes, Your Honor, thank you.
Okay. All right. So this is rescheduled for July 13th at 1:30. Mr. Williams, you should be contacted by the public defender's office prior to that occasion, okay?
Yes, sir.
All right. Anything else for the record, docket 2300258, Ms. Housefield?
Nothing for the people, Your Honor, thank you.
All right. So this is adjourned for good cause to July 13th at 1:30. Mr. Williams, do you have any questions of me?
No, sir.
All right. You should be all set. Thank you for your appearance today. That's all for the record, 2300258.
Thank you.
Yeah.
Thank
Yeah,
you.
thank you.
All right. This is the civil trial, and then this is Eskin. All right.
All right, guys. Yeah, sure. Hey, Greg.
All right, Mr. Milks, we've got your client here and we're gonna take an oral pre-sentence, Mr. Husky. Is it Mr. Husky? Dahowski has seen your client and she's going to give an oral pre-sentence report so we can wrap it up before we take him away. And that way we can do the sentencing right now.
Oh, wonderful. Awesome. Yeah, that's great. Thank you, Your Honor.
Yeah, you're welcome. So we've got her coming up and so we'll go on the record in just a few minutes, okay?
Excellent. Thank you, sir. I appreciate that.
All right. Thank everybody for your appearances today. This is on docket 22-01976. And this is the sentencing, kind of an expedited sentencing concerning Mr. Jeske because of the situation. Ms. Dahosky, do you have a oral report to give to the court concerning your interview with Mr. Jeske?
I do, Your Honor.
Okay, you may proceed.
Thank you. So I did meet with Mr. Jeske. We sort of did a expedited substance abuse assessment. Given that he's already been approved through Clinton County for TRICAP substance abuse placement, there was an assumption done that an assessment has already been completed and he met those qualifications. However, I did do our basic questionnaire with him. And he definitely met the criteria for a severe substance abuse disorder, specifically pertaining to alcohol, methamphetamines, and cocaine. He did fall into the early remission. However, that is due to incarceration. So it's sort of situational versus an actual remission of the substance abuse disorder. I also ran lean in criminal history, and Mr. Jeske was very forthright that he has a long criminal history, mainly out of Wisconsin. Of course, the charges that he has pending here or that he has currently going on here in Michigan. He admitted that out of his adult life, he's really only been free or not incarcerated of some kind for about a 9-year period. So I think he is well aware that he's got this long-standing criminal history. I did kind of do again shortened version of our risk assessment. He did advise he does have some family support here in this area. However, he is homeless. He does, have limited resources at this time. Obviously the longstanding substance abuse problem, longstanding, maybe poor decision-making based off of his substance use history, which would place him in our high needs category. I did do some follow-up as well. Clinton County is a 1-year jail sentence. He does have credit since January 8th, was when he was, taken into custody in Clinton County. So the credit essentially is around 6-month mark. The remaining portion of his jail sentence is suspended upon completion, a successful completion of the TRICAP program, which stands at about a 5-month program as sort of the standard. And then after release from TRICAP, he has 2 years of supervised probation, so follow-up treatment and services. The case in Eaton County mirrored that of Clinton County. So I believe that the plan at this point is going to be to supervise in Clinton County. However, I think he had kind of mentioned that he may end up moving to Ingham County with a family member or something, which may mean that case will be transferred to Ingham County for supervision. But regardless, we're looking at a 2-year period of probation upon completion of that TRICAP program. Mr. Jeske did verbalize a desire this time to stay clean. He does realize that, his life has not gone down a good path, that he is getting older, that, it's time that he makes these life changes. And, at this point, Your Honor, I would definitely recommend that on our case, we do credit time served, because both Clinton County and Eaton County are going to supervise that treatment and that ongoing level of care, which is ultimately what we would be looking for out of that program, or putting him on probation here. And I don't know that there's anything more we can do here on a 3rd probation case that he's not already going to receive out of the circuit court, either in Clinton or Eaton County. So the recommendation at this time is credit time served on this case, Your Honor.
All right, thank you. And then Mr. Colrider, your appearance for the record, and Mr. Milks, your appearance for the record. Oh, you're on mute, Mr. Colrider.
Well, in that case, this is Stephen Milks from the Eaton County Public Defender's Office, representing Mr. Jeske. Obviously, I'm appearing via Zoom for this last minute hearing, and Mr. Jeske is currently in court.
All right,
Thank you,
Mr.
Dale
Colwriter.
Coltrader. Yes, Dale Coltrader here on behalf of the people.
And then you, sir, are Jonathan Jeske, is that correct?
That's right.
All right, and you all heard the pre-sentence, the expedited the interview process. Mr. Colwriter, do you have, first of all, Mr. Milks, you've had the opportunity to hear Mr. Husky's recommendation. Do you have anything towards allocution?
Towards allocution, I would ask just that the court adopt the recommendations. I thank Ms. Duhosky. I know she's already incredibly busy, and the fact that she did this last minute is a real boon for my client and something that's going to help him get into treatment faster. So I hope the court, or would ask that the court adopt the recommendations. I do believe they're appropriate, and so we can get them into services. And thank you, Your Honor, as well, for also kind of expediting this too.
Mr. Colwriter?
Your Honor, I have nothing to add. I would defer to the court on this.
All right. Mr. Jeske, is there anything you'd like to say to the court before the court passes the sentence?
I just like to apologize to the city of Lansing and the courts for my behavior, my continued use of addiction, and it's thank the officers that brought this to my attention that the meth was killing me.
All right, the court is going to adopt the recommendation of Mr. Husky. Adopt the recommendation. So sentence is to adopt. So this is for plead guilty to the use of methamphetamine charge, and I'll adopt the recommendation that was set on the record, and sentence the defendant to time served on this file. There is a $75 crime victims' rights fee and a $50 state fee for $125. I'm going to waive fines and costs. And I will administratively close the file as to the $125 that's owed to the city of Lansing. It's my understanding Clinton and Eaton County are involved. We've already been accepted to TriCaps, which is the start in the right direction. So we'll let that take its course. All right, sir? All right. Were you going to print a judgment of sentence?
There really wasn't.
All right.
You just-
That's what I did. All right. So with that understanding, anything else for the record, docket 2201976, Mr. Colwriter?
Not from the people, Your Honor.
Mr. Milks?
Not from the defense, and thank you again.
All right. Thank you for your appearance, Mr. Husky. Sir, good luck to you, okay?
Thank you.
All right.
Anything for me, Your Honor?
You're all set. Thank you. Thank you so much.
Yep.
Thank you, Your Honor. Take care.
You too. Thank you, Mr. Colwriter. So if you can read my writing, you know what I wanted, and
I'll make it.
yeah, good luck with that. All right. So well, let's have the litigants and sir, what's your name again?
Abdallah.
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 All right. So come on up, and Ms. Shamumba and Mr. Musa Bakwa, come up. All right. So for our purposes, the plaintiff can sit over. You can sit there, and then we can sit right there. That's fine. And sir, state your name and spell your last name for the record.
My name is Abdallah Mukoma, last name Mukoma.
Okay. All right. So you know where we stand here. We came here on a formal hearing, and the defense asked for an interpreter. So did the plaintiff. Okay, so we ordered 2 interpreters with that understanding that it would place one interpreter in the middle of the of the allegations, okay? We've been told that the plaintiff has to be responsible for her own interpreter, okay? That the court will not provide an interpreter. So you're provided for the defense, okay?
And Vani, right now she came here asking if I can do.
All right. And Vonnie came down and said, so if they agree, we'll do both. Can you do both?
Yeah, I can do.
All right. All right.
Anasema jaji pale kwamba ndio tulikuwa tumepangiwa hapa tukuje kwamba na watafsirishi wawili. Sasa sana sana mimi wamenituma nikuje nimtafsirishe bwana, alafu wewe uletewe mtu mwingine. Sasa kwa muda huu sasa mwenye alikuwa anatafsirisha wewe hayupo hapa. Wananihitaji mimi kwamba nyinyi watu wawili ni watafsirishie.
So you agree to that? Okay. And sir, you agree to that?
Yes.
Okay. All right. So I'm going to swear you in now. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications to either party, so help you God?
Yes, Your Honor.
All right. So I'm calling to the record docket 2202536.
Yeah, anaita hiyo namba yangu kwamba ni 2313 katika na nimaliza 36.
And ma'am, you are Nima Shamumba.
Mama unaitwa Nima Shamumba?
Ndio.
Yes.
And sir, you are Mia Musubakula.
Na wewe unaitwa Mia Musubakula.
All right.
Yes.
This is the time set for a formal hearing in the matter,
Kwamba hapa
civil case.
Yeah, tumepangiwa kwamba ni tusikilizwe yale yalikujiwa hapa.
And so just so there's no misunderstanding, have the parties had the opportunity to speak through an interpreter concerning what's at issue here?
Uliwahi kujaribu kuongea, mlete mtu katikati yenu aongee kumaliza hizi habari?
Ms. Shamumba, have you had the opportunity to speak through an interpreter to the defendant?
Kwamba umewahi kuongea kwamba nina mtu yoyote katikati ya mtafsirishi ama kuhusiana hizi habari na kwa bwana
Kwa jamaa?
Yeah.
Ndio.
Yes.
Okay. And it's still your intent to go forward with the case for formal hearing?
Bado unataka kuendelea hii kesi iende na mbele?
Ndio.
Yes.
Okay. Now you understand that at formal hearing, I'm going to put you under oath and you're to provide any evidence concerning what's owed to you in this case.
Sema kwamba ni kwa kusema tuendelee kwamba ni yeye atakuweka kwanza wape alafu useme ile inahusiana kuhusiana hii kesi leo. Yes.
All right. And you're prepared to do that. You're prepared to provide the court any evidence that so that the court would have could rule in your position by a preponderance of the evidence, but you have to provide the court some evidence.
Sema kwamba ni mahakamani wanataka ushahidi kamili kwamba ni kuhusiana zile faranga umesema na makaratasi yake yote inaonyesha kwamba ni ili wamshike huu bwana kwamba ni pesa hizo zilienda namna gani. Yes.
All right. All right. And so if that's your understanding, I'm going to swear her in and then she can testify and you translate to me as best you can. All right. And if you need to break her up, feel free to, okay?
Nasema kwamba ni sasa utaapa, alafu utaniambia au utasema kwamba ni alafu na mimi nitamshirishi kwa jaji. Okay.
Okay, raise your right hand.
Nyanyua mkono wa kuume.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Kwamba ni hapo umekaa leo unaapa kwamba ni kila kitu utasema itakuwa ni ukweli, hakuna cha uongo unaweza ongeza, ndio? Yes.
All right. All right. Tell me your version of these events, and then if you have any documentation, we'll mark it and we'll admit it into evidence.
Nasema tuambie kwamba ni habari kuhusiana hizi habari leo umetuletea. Kama uko na karatasi yoyote tena unatupa, tutaandikisha tuweke kwa ushahidi.
Yeye ni mume wangu.
He is my husband.
Tumekaa naye muda mrefu kutoka Afrika.
We've been together for a while we were in Africa.
Na wakati tulipofika hapa Michigan mambo yakaendeka vizuri.
When we came here to Michigan, everything didn't go well.
Wakati tulifika tulitoka Georgia tukanunua nyumba hapa.
We came from Georgia and came to Lansing, Michigan and buy a house here.
Wakati ilikuwa 2018.
In 2018.
Tukafanya fujo kabisa.
So we had an argument between us.
Akanifukuza.
He kicked me out.
Nikaenda ikaa kwa sister wangu.
I went to live with my sister.
Wakati nilikaa kwa sister wangu nikatafuta pesa.
When I lived with my sister for a while, I tried to make money.
Wakati nilipata pesa yangu kidogo,
When I got my money,
pale tukaanza tena rudishana mimi naye.
then we came back together again.
Nikamwelezea natafuta na mimi kununua nyumba.
And I told him that I'm trying to buy a house myself.
Kwa sababu hii kila wakati ulikuwa unaniambia nitoke kwenye nyumba yako, mimi siwezi.
I don't want to be like all the time you are asking me to leave out from my house and come back together. That's what I don't want to do.
Nikampigia ndugu yangu mwenye yuko Ohio phone.
I call my brother who is in Ohio.
Akaniambia amepata nyumba online ya bei rahisi.
And he told me that he got a house which is cheaper in Ohio.
Nikamwelezea sikuwa najua tembeza gari.
I told him that I do not know how to drive a car.
Anisaidie tuende Ohio ninunue.
And I asked if you can travel with me or you can take me to Ohio and buy that house.
Nikapata nyumba tukalipa pesa.
And I got a house, I paid the money.
Tukarudia.
And I came back.
Kisha miezi fulani naomba nitafute pesa ya kufix nyumba.
Then a couple months later on, I tried to make money to fix the house that I bought.
Nikapigia rafiki ule ndugu yangu simu huko.
I called my brother there in Ohio.
Akaniambia nyumba iko salama.
And he told me that the house is okay.
Kisha tukakorogana tena naye kwa maana familia yetu kila wakati tunafanya fujo kila wakati.
Then again the argument between me and him, it came back again.
Tukafanya fujo kweli, polisi zikakuja.
And that argument was a big one because until the police involved in that case.
Nikakutana ana mtu alileta ndani ya nyumba.
So when I came back, I saw like he has someone else in the house.
Wakati nilikutana naleta ule Spanish ndani ya nyumba yangu.
When I saw that woman, the Spanish lady came in my house.
Kweli wakanitukana zaidi.
Then he cursed me a lot.
Polisi kakuja kaniambia hautaingia ndani ya nyumba.
Then we called the police. The police came and they asked me not to get into the house.
Kwa maana wanaweza kukufanya vibaya.
Maybe they can do something, they can threaten you.
Mimi na mtoto wangu tukienda tafuta hoteli ya kulala.
And on that night, me and my son, we went to have a motel.
Tukalala huko kwa hotel, tukarudi asubuhi.
We slept there in the motel that night and came back in the morning.
Wakati nilifika asubuhi nikamwambia nifungulie, nikafikiri kwa sababu alikuwa na hasira ama sijui nini niliendeka kuweka mwanamke ndani ya nyumba.
So in that morning when I came back, I thought that maybe last night he was angry because he put someone else in the house. Then just I came back in the morning so that if he is down and he can open the door for me.
Akakataa nifungulia.
He didn't want to open for me.
Akasema polisi imesema nitoke kabisa, mimi naye hatuna tena relation.
Then he told me that like the police told me do not let her get in the house because we don't have relationship with her.
Mtoto yuko kwenye period na lazima anawe.
And I told him that your daughter, she got a period, she needs to take a shower in the house.
Akakataa kufungua mlango.
And he didn't want to open.
Asire kanipata nikachukua jiwe mbele ya mlango.
Then by that time I've become angry and I took a big stone.
Nikabomoa kioo ya mlango.
Then I hit the window.
Nikafungua mlango.
I opened the door.
Nikaingia na mtoto.
And I get in with my daughter.
Wakati niliingia yeye akatoka kwa mlango wa nyuma.
Then when I get in and he get out from the other door outside,
akaenda piga polisi tena.
He called a police again.
Wakati alipigia polisi.
When he called the police,
polisi tena ikakuja na mara pili tena.
Then the police came the second time.
Ikasema tulikuja hapa usiku yote jana tena saa hii asubuhi mnatuita.
And the police said we were here yesterday and today this morning you're calling us again.
Nikamwambia polisi sasa mimi sijui kwa nenda na mtoto wangu.
I told the police that I do not know where I can go with my daughter.
Lazima niingie mnyumba.
So I have to get into the house.
Polisi kamwambia nyumba na vyumba vingapi?
Then the police asked him how many bedrooms are in the house.
Akasema 3.
Then he says 3.
Wakamuuliza kuko fasi kwenye utaenda?
Yeah, the police asked him, do you have a place where you can go?
Akasema
No, he said no, he doesn't have.
Na mimi sina familia ya kwenda.
And I do not, myself, I do not have a place where to go and no family.
Polisi kasema hii itakuwa mwisho kutuita.
So the police told us that has to be the last minute to call me.
Kwa sababu mnatuita hapa sana.
Then you are calling us a lot, many times.
Kila mmoja achukue room yake.
Everyone has to take a room, one room.
Kama vile mume wako amesema hakupendi tena.
The way your husband says he is not in love with you anymore.
Usimchokoze hata siku moja.
And don't try to talk to him.
Na yeye asikuchokoze.
And him, he doesn't have to talk to you.
Nikaona pale ya kubaki hivyo nyumba moja.
Then myself seeing like this, the situation is this.
Na tupatane mimi naye.
If I'm not talking to him,
nikaenda Ohio.
Then I moved out. I went to
Nikaenda
Ohio.
tafuta ile nyumba yangu niingia na mtoto wangu.
I went to there and find my house, the one I bought, and stay there with my daughter.
Nikakutana ile nyumba kuna mtu ndani.
Then when I went to Ohio, I got the house also. Someone else was in the house.
Nikauliza hii ni nyumba yangu.
Then I told him, this is my house.
Ule mume wa ndani akasema hii nimenunua.
And the guy who was in the house, he said, I bought the house.
Nikasikia kulia zaidi.
And I tried to cry more.
Nikampigia simu.
I called him.
Nikamuuliza wewe uliuza nyumba yangu?
I called him and asked, did you sell my house?
Akasema hapana.
He said no.
Kisha ule ndugu yangu wa Ohio.
Then my brother in Ohio
akaniambia wende kwa wale ambao wanauzisha nyumba.
And my brother in Ohio, he asked me to go and ask the retailers.
Ile nyumba nani aliuza?
Ask the retailers who sell this house.
Nikaenda kwa ule mwanaume.
And I went there.
Nikambebea kwa maana toka nilinunua ile nyumba sikukuwa na address, yenjo alibakiaka na title na ma-address yote.
So he had all the documents. When I bought the house in Ohio, he had all the documents. I didn't have the documents, I didn't have paper, I didn't have the address.
Mungu akanisaidia nikapata check.
And I received a check.
Banaandika kwa Neema Shamamba.
The check was written in Neema Shamamba.
Ya city ya Ohio.
The city of Ohio wrote a check to.
Iko kama ni 800.
It was 800 check.
Nikajiuliza hii pesa ilitoka wapi?
Then I asked myself, where is this money came from?
Wakati nilimuuliza,
I asked him.
Akaniambia inawezekana tu sisi tumekutumia.
And he told me that maybe the city sent to you.
Nikauliza uko sister wangu iko huko.
Then I asked my sister.
Akaniambia sasa ile address ni address gani?
Then the sister asked me which address is the address that you are talking.
Inawezekana sasa unapata address kwa nyumba yako iko.
Maybe it's the address where your house is located.
Kisha nikasema acha nilete.
Then I said, let me bring the check.
Nikaenda Ohio.
I went to Ohio.
Tukaenda kwa ule baba wa kuuza nyumba.
Then I went to the retailer guy who's selling the houses.
Akaona ile check akaweka address ya hiyo nyumba.
He took the check and put the address.
Connect sijui kama na city ya huko.
And also he connected with the city of Ohio.
Akamuonesha jinsi nyumba inanunuliwa na mtu fulani.
Then he showed all the documents and who sold the house and who bought the house.
Wanasema nyumba imenunuliwa na watu watatu toka nyumba ilikuwa kwenye program.
So the house was bought for 3 people. Concerning when we see all these documents, 3 people bought this house.
Unamjua huyu Mia Msobokelwa?
Do you know Mia Msobokela?
Nikasema ndio ni.
I say yes, he's my husband.
Aseme ndio Mia Msobokelwa ndio ameuza hii nyumba na pesa zimekuwa transfer ku Bank of America in Lansing.
Asema kwamba ni Mia Msobokelwa, he's the one who sold this house and the money went to his account of the Bank of America account.
Na imeuza 20,000.
And the house was sold for 20,000.
Nikamuuliza tena akakataa.
I asked him and he refused.
Ilikuwa November hapa.
In November.
Ndio wakati hapo wakiniambia nitoke kwenye nyumba yake zaidi.
So that was the last moment he's asking me to move out from my house.
Ndio na mimi nikasema nirudishie basi nyumba yangu.
And I told him that, can you bring back my house that you sold?
Kwa maana hii nyumba tuko ndani hapa.
Because the house that we are living in here in Lansing,
Nilijua kama tumechanga pesa pamoja tukanunua pamoja.
I know that you paid money and I paid money, we buy together.
Lakini wakati alienda kwenye kuandika vikaratasi,
but when he wants to write down the documents,
akuniandika kama mke wake.
He didn't add her as a wife.
Na mimi nataka nyumba yangu.
And myself, I need my house.
Akakataa kasema sio yeye.
And he said, it's not me who sold your house.
Ndio nikauliza huko, wakanielezea wewe uende kwenye court, hiyo maneno itaishia kwenye court.
And when I asked them then Ohio, they bought the house again, they asked me to go to the court and the court will sort that out.
Court itakusaidia.
The court will help you to figure out.
Na ndio maana nilikujaka hapa.
That's why I came here.
Ndio kunisaidia.
To get assistance.
Karatasi ambayo tu nilikuwa nayo,
the paper that I have,
ni ile tu ya check.
I have only the check showing that the
Kwa maana title ya nyumba,
the title,
yeye mwenyewe tu ndio alikuwa iko nayo.
he has all the documents for the house.
Ile check tu ndio nilikuwa nimebakia nayo ya kunionyesha address ya nyumba kwenye ilikuwa.
Only the check that I got, the 800, I have only that kind of paper or documents.
So the entire suit is based on a house that was bought in Ohio.
Sasa sana sana haya maneno tunaongea ni ile ya nyumba imenunuliwa Ohio. Yes.
And the only documentation you have concerning your association or ownership of the house would be the check that was written from the state of Ohio to you for $800.
Ndio kwamba ni kile karatasi uko nayo kuonyesha kwamba hii nyumba ni ya kwako, yani ni hiyo tu cheki imeandikishwa kwa Ohio.
Ndio.
Yes.
You don't have any documentation indicating that you are the owner of the house or the house is in your name, any title, anything along those lines.
Hakuna karatasi yoyote nyingine inaonyesha nyumba ni ya kwako, iko na majina yako.
Title iko na majina yangu, lakini yeye kama vile mume, yeye ndio mwenye aliwekaka.
Yes, the title of the house, it got my name on it, but the way we were together, I gave him all the documents. He has the documents.
Lakini wakati alienda kauza, sikujua wakati alienda kauza hiyo nyumba.
I did not know when he went and sell that house.
All right. Sir, I'm going to swear you in, and then I'm going to hear you've heard what the plaintiff said in this case, correct?
Sema umesikia yale alisema mkeo.
Right. And so rather than have a cross-examination or anything like that through the interpreter, I'm just going to have you tell me your version or your response to the plaintiff's case.
Haya, nataka uniambie jibu kuhusiana haya maneno alisema. Nyanyua mkono juu kwanza.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Ndio kwamba kwamba. Yes.
Okay, you may proceed.
Endelea.
Kufuatana na maneno yote anazungumza hapo.
What she said,
nyingi ni uongo.
All is lie.
Sababu ya nini?
Because of
tulikuwa tunaishi Georgia, Atlanta.
We were living in Georgia, Atlanta.
Kutoka Afrika tukafikia Georgia, Atlanta.
Came from Africa to Georgia, Atlanta.
In 2016.
In 2016.
Yeye akapiga mtoto glass mkichwa.
She hit the child with glass on the head.
Wakamfunga wakamtia mjela.
So she was in prison. She was arrested.
Nikaenda kule nikamtetea, nikalipa pesa wakamfungua.
I went there and banned her out.
But wakampatia akuwe mbali na jamaa.
So she was told that she has to stay away from the person who were together.
Hatukukuwa pamoja.
We were not together.
Nikakuja hapa Lansing.
And I came here in Lansing.
Nikanunua nyumba hapa Lansing.
I bought the house in Lansing.
Mimi na watoto peke yake.
Me and my children.
Sikukuwa na mke.
I wasn't with her.
Nyuma ya hapo
Then after that,
nikaanza kazi hapo Lansing.
I started working here in Lansing.
Kulikuwa kunapita kama miezi 2 wala 3.
After 3 months, 2 months to 3 months,
naona mtu ananipigia simu anasema niko kwa airport.
Then I receive a phone call.
Nakuja kuangalia mtoto.
Asking like I am at the airport. I came to see the daughter.
Kwa sababu mimi na yeye tuko na mtoto mmoja.
And between us we have 1 child.
Na niko na wengine watoto 3 ambao mama wao alikuwa amekufa.
And I have 3 child from different mom who passed away.
So nilikuwa na watoto wote na ule nilizala naye.
The one I had all the children, the 4 of them. The one that I have with her and the 3.
Akakuja tukakaa hapo.
Then she came and lived with me here.
Ikafika muda yenye atuelewane.
Yeah, we don't communicate well.
Anakuwa ananitafutia shida kila siku.
And all the time she's trying to make me in trouble.
Simfanyizia hata kitu lakini anapigia polisi.
Even if I didn't do anything to her, she just called police.
Polisi kila wakati ilikuwa nafika nyumbani.
Every time the police were arriving to our house.
Polisi wanafanya investigation, wanakutana kila kitu wanawaitia ni uongo.
The police, they're trying to investigate both of them, and later on they got like everything is lying, nothing happened.
Sikuwa naelewa ni nini.
I was not understanding what's going on.
Bas, ikafika muda yenye tukaenda kununua nyumba.
Then it came a time that we went to buy a house.
Mimi watoto wote wanakuwa wanakomaa, mimi sifanye tax ya America.
Then all the children, they already grown up. I don't file tax with them.
Na nikapana tax nitapata kama 500 wala 1000.
And when I got tax return, if I file my tax, I just get 1,000 or 500.
Lakini tuko na mtoto mmoja mwenye alikuwa yaeneza 18.
But we have only 1 child that didn't hit 18 yet.
Na yeye ndio anamfanyizia tax.
And she's the one who's filing with the child.
So, mimi najua kama hiyo pesa ya tax ni ya family.
I thought that all the money that she's filing with that child is for the family.
Ikafika wakati yenyewe akapata tax wakampatia 8,000.
Then there is a time that she received 8,000 from the tax return.
Nikatia kwa 5,000.
Then I took 5,000.
Nikatia kwa 2,000.
And she put not umesema
nikatia 2,000 nyingine yake.
Wewe ukatia
5,000.
Yeah, I put 5,000 on the table and she put 2,000.
Tukaenda tukanunua, kuna warafiki huko Ohio.
Then we went to buy the house in Ohio.
Wanakuwa na manyumba ya cheap.
And they told us there is a house
tukanunua
here.
Nyumba kwa 15,000.
We bought that house for 15,000.
Ikalomba tutengeneze nyumba. Sisi tuende ndani.
Then I asked, can we fix the house so that we can move in?
Tukaenda naye kule.
I went with her.
Yeye akakatala nyumba.
And she says, I do not want this house. I do not want this house.
Nyumba ikabakia hivi.
Then the house remained the same.
Nyumba atuilipie tax.
We don't pay the tax for the house.
Atukate mayani kutoka nyumba.
We don't cut the grass outside.
Snow ikamwangika, snow inabakia hapo.
Even if snow comes, then the snow is gonna remain like that.
Na hiyo anasema kama nyumba iko kwa jina yake yeye mwenyewe hapa. Nyumba iko jina yetu mimi na yeye.
So the house that she's saying that it's for, the name is on her only, it's not. The name is for both of us.
Bas. Tukaambia wale wandugu wako huko.
And we told the cousins there.
Utafute watu wa kuuza nyumba.
Then you gotta find some people who's gonna sell this house.
Bali tupatia watu wao wa agent.
So they give us the numbers for the agents in Ohio.
Mtu wao wa agent ndio mwenye alikuwa na nyumba.
The agents, they are the one who sold the house.
So mimi kwangu niko surprised.
Then I was surprising.
Na mimi ningelitaka nione hiyo paper ya kuonesha kama mu account yangu mlingia 20,000 ya hiyo nyumba.
I didn't receive any money from the agents that they were selling the house. Even I want to see if she has any paper showing that the money went to my account.
Nilikuwa napata mtu wa kununua nyumba.
I got someone who gonna buy the house.
Wakati niliuza nyumba walinipatia pesa nusu.
Then umeuzisha nyumba gani?
Hiyo nyumba nilikuwa napata mtu wa kununua nyumba.
Okay, he got someone who buy the house.
Yeye aliniletea fujo yangu mingi sana.
And she didn't want to sell that house there.
Huyo mtu akasema sitauza tena hiyo nyumba.
And the person that wanted to take that house to buy the house says, no, I'm not gonna buy it.
Bring back my money.
If there's an argument between you and your wife, bring back my money that I gave to
Na
you.
nikaishia hapo.
And I took that money, give back to that guy, and I didn't sell the house again.
Hiyo yote fujo ananiletea.
All this argument on problem is just bringing
Na
to
mimi
me.
sijui ni nini.
I don't know what's going on.
Na vile anasema kesi iendelee mbele.
Which is saying that we're gonna move forward.
Nitaenda gisi yeye atataka.
Then I will go forward the way that she wants me to go forward with this case.
Lakini mimi sina shida.
I do not have problem with that.
But when he says go forward, does he mean that, does he have any documentation indicating that they were both on the house in Ohio?
Uko na hiyo makaratasi kuonyesha kwamba nyinyi watu wawili mko kwa hiyo majina hapo Ohio?
Hakuna hata document moja nimekusha kuwahi kupata kwa hiyo nyumba.
No, he doesn't have even one document from that house.
But all right. Well, I've had the opportunity to listen to both. So
Ndio nimepata muda wa kuwasikiliza nyinyi watu wawili.
In regards to file 2202-536.
Kwamba ni kuhusiana hii file hapa, jaji anayeongea namba zake.
The formal hearing was held.
Kwamba ni mkutano wa leo uliitanwa hapa.
And the plaintiff and the defense testified.
Ndio kwamba ni mke na mwanaume nao waliongea kwao.
I am uncertain if I have jurisdiction over a house in Ohio.
Anasema kwamba ni mimi mwenyewe sijui kwamba ni masharia yale wako nayo huko hapo Ohio.
The allegation, and I wrote this down, was that the plaintiff was seeking $20,000 that was owed to
Ndio
her.
kwamba nimeandika hapa kwamba mwenye kuumizwa anataka 20,000 kwako.
And that's no small amount, $20,000.
Hayo sio pesa ndogo.
So and now I've learned, as we've gotten into the facts, that the $20,000 is based on a house that was sold in Ohio that she wants to be compensated for.
Anasema kwamba ni hapa nimeelewa kwamba ni hizo 20,000 ni nyumba imeuzishwa kutoka Ohio, kwamba ninataka kulipishiwa.
Say, one, I probably do not have jurisdiction over a house in Ohio, where this lawsuit probably should be originated.
Anasema kwamba ni hapa kwa kusema kwamba ni niende nitafute hizo pesa za Ohio, kwamba sio kambi yangu huko, kwamba ni sina hiyo haki, ni lazima itafutiwe upande mwingine.
I am comfortable though with indicating that the plaintiff has to prove her case by preponderance of the evidence.
Ndio kwamba ni mimi nataka ushahidi kamili kuhusiana hii 20,000 inahitajika.
And though I believe many things that she said today, I think her testimony is quite compelling.
Anasema kwamba ninaamini yale alisema leo yote, kwamba ninafutukulia.
There's not any documentation to support anything she's indicating.
Yani hakuna karatasi yoyote inaweza saidia kwa haya maneno umesema.
With that understanding, in a $20,000 request in a complaint,
sema kwa kuelewa mimi kwamba 20,000 mtu anataka,
I'm going to find that the plaintiff has failed to prove her case at a preponderance standard.
Ndio kwamba hapa nitaandika kwamba ni mwenye kuleta hii kesi kwamba ni ameanguka kuleta makaratasi yale yanahitajika.
And the case is dismissed.
Ndio kwamba kesi kwa muda huu imeachwa.
I will indicate for the record that she may want to look into Ohio law concerning a house that was sold that was her property, but in Michigan it becomes a problem.
Anasema kwamba ninapenda kwamba uende Ohio kwamba ukafungue hiyo kesi, kwa sababu hii hapa kwa Michigan itakuwa ni shida, hawezi kufuatilia.
Okay, anything else for the record in docket 2202-536?
Kuna kitu chochote tunataka tuongeze kwa hii docket number hapo jaji amehitaji?
Does the plaintiff understand the court's ruling?
Kwamba nimeelewa, yani sheria za mahakamani. Yes.
Does the defendant understand the court's ruling?
Nimeelewa, yani vile jaji amesema. Yes.
All right. That's all for the record in 2202-536.
Tumemaliza hiyo hapo, hiyo ndio.
Thank you for your appearance today and thank you for your assistance.
Karibuni, asanteni kwa kuja hapa na niambie mimi karibu sana. Naweza enda.
Jaji anasema kesi endeavor wapi?
Kesi imeisha hapa Michigan, mnaweza enda mfungue kesi wapi. Thank you.
Thank you. And thank you for your assistance today. I know this was a lot of interpreting today.
Thank you. May I leave?
You can, you're free to go. Do we need to sign anything for you? Or you're all set. All right, thank you. All right, Mr. Barry, you are here on Mr. Eskin.
Yes, Your Honor.
All right, and he's here or he's in jail?
He's in custody.
All right. So is he gonna join us by Zoom or are we gonna go get him? Okay, so we gotta go to both of them? All right. Do you need help getting? Okay, all right. So we'll have both of those defendants brought up and then we'll put whatever happens on the record. So come get me when we're ready.
All right.
Yeah, you know, one of those things where apparently there's decisions made before arguments.
Thank you for being so nice to me earlier.
So-
I felt terrible. But thank you for not keeping me in there for.
Well, no, I wasn't gonna make you sit through the rest of that awful day.
Yeah, I had ski.
I'm not that mean, Mr. Pratt. Well,
Yeah. That's, I tried getting in touch with the victims the day before the restitution. We didn't have it. I didn't hear from my girl. And then I looked at the PSIs and saw they've been, informed by probation. Get them restitution information.
Certainly. At least the one guy I think was trying to get a huge windfall. I'm like, no way.
They were asking $10,000. Well, it's not that bad. I mean, I have one that's coming for, I think it's
Yeah,
for
but-
restitution. Animal.
Oh, they're ridiculous. They are ridiculous. Although you'll probably get a grant. Yeah. Yeah.
Yeah. That one.
So he never responded to my email lately, was why he was arraigned before. He was arrested on the second, right on fourth or something like that. But like, why until last night to bring this up?
Because I didn't have him on my schedule. I didn't see him
in the system.
Well, I didn't see him coming up as for the PCC until I was looking into the PCCs.
Yeah.
For Friday yesterday. So that was,
And they're saying somebody should have flagged it before.
yeah, I didn't know he had been caught until I saw that. So yeah, no.
It's whoever in your office is supposed to flag that.
Yeah, and the phone, she's like, I've been in. I got to the office like 7:30. I've been here since 8 a.m. The judge had 3 dockets this morning, so I've been. I didn't sleep in the place.
He had.
He
What's
covered-
that?
I said, I didn't sleep last night. That makes you feel better.
I got 2 hours. Yeah, he was, the judge was covering Judge Ward and Judge Simmons today as well. For PCC.
Oh, yeah.
Yeah. We got it all done in about 4 hours. I think 4.5 hours.
no, we didn't. We have not gotten off the record since 8.
Well, the morning stuff we got done.
At 1:45.
Yeah. But that's still 3 dockets.
No, actually, we didn't. We didn't finish Mr. Johnson's till later. It was after 1.
And if this gets adjourned, I'm gonna go right back to another board. Yeah.
Where?
Back in Flint. Yeah.
That office.
I've got an attorney.
Yes, man.
Prosecutor's office? Oh, yeah. It's like Heather O'Donnell handed me an acquittal last week.
She what?
Handed me her acquittal last week.
She handed what?
Handed me the acquittal last week.
Oh.
She, I can't say it to her face, but I almost want to say, thank you for helping pad my stats.
I don't know those stats, but I heard the AG is takes
I have no information. I don't know if somebody's just trying to spread rumors and gossip.
Have you heard that rumor?
Absolutely not. I would like to see it happen. But I've heard no rumor that that is on the horizon of happening right now.
Huh, someone
But
that
how long did someone say this?
I just found that out. Just 2 days, 3 days.
So I would know by now. But it certainly would not surprise me if in fact that does happen, given the current conditions. And I also know of some stuff recently that would support the conclusion of that happening based upon what recently happened. And I'm not at liberty to say, but yeah. So I'm not saying it's untrue, and I'm not saying that I'd be surprised. I'm saying that
That's what I heard. For what it's worth.
Yeah. If it is true, I'd be very surprised that you somehow found out before me.
Well, you'd be surprised how connected I am.
Well, I'm not saying you aren't, but you'd be, I mean, it doesn't take a genius to know how connected I am there, because that's,
Right.
you know.
I got that too. That's why I brought it up to you.
Yeah, like Ryan would probably be telling me immediately.
Yeah, it's on my windshield. He wants to talk to us.
No, the strictly driving law, I think that.
Oh,
That was gonna be interesting. That's.
yeah. I don't know. Are you guys really gonna do much about that? I mean, come on.
I mean, I looked at it.
What I see that is happening is a lot more search and seizure. It's cops using that as a reason. Gut feeling cars.
Yeah.
That's what I think.
Well, that's part of the. That's, I'm wondering how that's gonna be.
That's what I really think. I think cops are gonna use that.
Probably told you when I
It does say, I'm just like I said, I'm looking at the legal updates that, the police officer shall not search a vehicle or the driver or passenger.
No, I know, but they always, yeah.
No, I'm just reading this.
Yeah, but that doesn't get you any good feeling that it's still not gonna be.
Does it matter if you go in
How do you, I mean, it's just, well, it's just.
Just have to apply to the job, that's on site, yeah, to the job,
Yeah. They're gonna use it.
But I have friend's sister who did that last year, and she only made $18 an hour. Pretty water.
So you gotta remove the head.
Insurance, right. Sorry, but-
Man, I said, sir.
Can I ask a question? One more. It's small. I was thinking more like the back, because they're funny. They seem like they have lots of, their Facebook pages.
This, my friend's sister said that already in touch. It's an amazing place to work.
I've never heard
Still
of
get-
that already.
She said you still get interesting stuff, but it's slow enough pace where you're not overworked.
I've never heard anything bad about it.
You work 14 days a month.
Wow, that's great.
It's 12-hour shifts, 14 days a month, so it's
I know, East Lansing's got kind of a crap reputation, especially with their. Yeah, I don't think you want to do those attachments. Just like that, okay. I can-
I don't think it is, except for the cases. You were in the Easton County?
Yeah.
Oh, my God. That place is a zoo.
Well, now.
Yeah, but that's always, how long ago? How long ago? Okay, I'm not talking about the prosecutor's office. Oh, bench. It's just, God, you talk about politics, judges that don't like each other. It's referees quitting all the time.
I guess one of the judges there. He just seems to fire off the hip, but he doesn't know where he's going.
After Nick and Woodman were in the house. Yeah, he does, so Nick or James.
That attorneys that was here in Indian County. Tracy.
I sat through that election. Never worked.
Oh, I see, I haven't heard anything about that.
What was, a couple of one of the things, which I'm sure you've heard about. Recent president. Yeah, well,
No.
Other one. And somebody wouldn't say that. Because of the ties with the hot. They were looking possible. Charges. But the House Police Department's investigation is pretty. Twitter page, whatever, and let's go.
Yeah, that's not how that works.
Well, but then, so it's kind of thing for investigation, and then, of course, he's going. They're not gonna prosecute him, so.
What was I asking that? if he was available. I was asking to come sit here for a second. I didn't have a phone. Oh, no. I just needed him to sit here for a second.
Barry, are you ready? Are you ready?
Sure.
Right.
Yes, ma'am. Yeah. All rise.
You be seated. All right. Put all my stuff here. All right, so we're on the record in docket 23012227 and 23012229. That is people of the state of Michigan in 227 versus Duval Gaskin, and in 229 Kejuan Eskin. So in regards to Mr. Gaskin, will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, may it please the court, David B. Carter Jr. on behalf of Mr. Gaskin, who is present sitting at council table.
And sir, you are Duval Gaskin?
Yes, sir.
Okay, thank you. And as to 23012229, will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Ronald Barrett appearing on behalf of Kejuan Eskin, who is standing to my right in the jury box. I have not set up my laptop or anything yet because it's my understanding the prosecutor has a request and I don't know what the result that's going to be before setting up.
Fair enough. And you are Kejuan Eskin?
Yeah.
Thank you. This is the time set for a preliminary examination today. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor. At this time, the people would be asking for an adjournment of this preliminary examination in these matters. And that would be under MCL 766.4 and the corresponding court rule MCR 6.110. There is a third co-defendant in this matter, and that would be, Your Honor, a Sergeant Wawe. And that's case number 23-01228. He, I believe, was arraigned on June 2nd and is scheduled for a preliminary or a probable cause conference tomorrow in front of Your Honor. And so in order to consolidate all of these cases and only hold one preliminary examination in this matter, the people would be asking for an adjournment under that court rule.
Right, and so he is a co-defendant in the case, is that correct?
Yes, Your Honor.
All right. Mr. Carter, any response to the motion to adjourn for co-defendant or in order to incorporate all three co-defendants in one preliminary examination? Your response.
Thank you, Your Honor. Well, doing some research regarding the issue, I understand that the statute does say shall So that kind of puts me in a bind as far as a legal argument to contest that. However, I would indicate that my client has been incarcerated for quite some time, and it's a 75,000, I believe, a cash surety bond. Is it cash surety or 10%? And I understand that this is not my client's reason for the delay, is that a third party has been picked up prior to his preliminary exam. At this time, I'd ask the court to consider lowering his bond, because this is a result of not his being that the preliminary exam is going to be pushed out. Not only is it going to end up getting pushed out to at least the 14-day rule for this new co-defendant that picked up, but it's my understanding there's obviously 2 other attorney schedules that have to now be coordinated with the prosecutors to find an open date for a preliminary exam that I think would probably be more than a 2-hour block, or at least a 2-hour block for a preliminary exam. So that's going to be even more time consuming on my client being in custody and awaiting a resolution in this matter.
Thank you. And then Mr. Barry, on behalf of your client, Mr. Eskin.
Thank you, Your Honor. Well, frankly, I think there needs to be some further delving into the statute rather than conclusory statements, just simply because there's the word shall in it. If you look at the statute, MCL 766.4 subsection 5, it indicates that if one or more of the defendants have been charged on the complaints listing co-defendants with a felony or felonies, the probable cause conference and the preliminary examination for those defendants who have been arrested and arraigned at least 72 hours before the conference on those charges shall be consolidated. So the issue we have here is clearly Mr. Gaskin and Mr. Eskin are those defendants that they were arraigned and prior to 72 hours prior to the conference, and then obviously we have the issue now where they've been joined together to run this preliminary examination. Now we have, after Mr. Eskin's been in custody for 56 days, and another co-defendant who's now been in custody for 13 days, now suddenly being saying, oh, well, we need to have the preliminary examination run all 3 together. I understand the request for efficiency for a judicial economy, but this statute is not applicable as far as any kind of mandate. And because the new co-defendant, Mr. Huawei, was not arraigned 72 hours prior to the probable cause conference for Mr. Gaskin and Mr. Eskin. Therefore, that statute does not mandate that he be included in this preliminary examination. To the extent that the court would somehow want to circumvent the statute, or even the prosecution to circumvent that statute and say, well, it's good cause. Well, in the law, we look at specific laws rather than general in making our application. So when we have a specific statute that says when they shall be joined together and run, we don't then turn to a general proposition for good cause to ignore the effect of that statute. Otherwise, it would completely ignore the 72-hour requirement of that statute, and every single time they added a new co-defendant, if the preliminary examination hadn't been held yet, there'd be adjourned. And that would entirely usurp that statute and give it no meaning. And because of that, I think the court has to deny the request that it's not, Mr. Huawei was not arraigned within 72 hours of conference, and it is not sufficient for good cause because you have to get that statute effect. If in the event the court is going to adjourn this matter despite my objection, I join Mr. Carter in the same arguments he makes. We have clients that are presumed to be innocent. We're not going to try the case, but these facts are very tenuous at best in making the case for probable cause in this matter. And frankly, we have a child who's been in custody and having to endure all of this time by no fault of his own. And so obviously the delay would not be attributable to the defendant either. And one of the factors the court can consider is, the strengths of the case and kind of go from there. But again, I don't want to really get into that issue right now because there are witnesses present in the courtroom. Thank you.
Thank you. Mr. Brodowitz, response to the objections to your motion to adjourn.
Yes, Your Honor, just briefly as to the objection under the statute. The statute does say those defendants who have been arrested and arraigned at least 72 hours prior to the conference. Mr. Huawei was arraigned at least 72 hours prior to this conference here. He was arraigned on June 2nd. Therefore, I do believe under the statute, as Mr. Carter pointed out, it does say that the court shall adjourn to join them into one preliminary conference, Your Honor.
Your Honor, this is not a conference. We are scheduled for preliminary examination today. We had the probable cause conference in these cases over a month ago.
So the probable cause conference was held on, I believe, we adjourned for good cause on May 25th, and then was set for today's date, May 25th. There was a conflicts counsel that we adjourned at one time to get conflict counsel in the matter. I'm familiar with the statute concerning joining co-defendants concerning the preliminary examination. It does say shall, that's a fair statement, although there are times where simply a co-defendant cannot be found, and so the court will make a determination that we should go forward on the co-defendants. That doesn't seem the fact in this matter. We have the co-defendant set for probable cause and preliminary examination. Actually, I think he's set for probable cause conference tomorrow in front of Judge Buchanan. And so we can get a date certain in regards to the 3 co-defendants and having the preliminary examination set on that date. I will indicate for the record that I expect that whatever date is chosen, we're going to have the preliminary examination on. All right. There'll be no more adjournments. There'll be no more. We're going to have the preliminary examination on that date. So I'm going to grant the motion for adjournment based on the court rule. When is the preliminary examination set for, Mr.
June 23rd at 8:30.
So counsel does make very good arguments concerning the incarceration of their clients. We have a June 23rd date at 8:30 for the 3rd co-defendant. I will indicate that they are allegations, but they're probable cause allegations that have made in regards to Mr. Duval are 12 counts of assaultive behavior and felony firearm. And as for Mr. Eskin, they are 4 counts of 1 life offense, a 20-year, and 2 felony firearm counts. So they are not small matters that we're dealing with. The preliminary examination on the 3rd co-defendant is set for June 23rd at 8:30. Mr. Carter, does that work with your schedule to set this prelim date that is out a week or so in order to keep the inertia of this case going?
I'm sorry, the date for the preliminary exam for that individual is for the 23rd?
23rd at 8:30. Okay.
And I overheard you say the probable cause conference is being held in front of
Judge Buchanan tomorrow.
Is that because
that's
you're not here?
That's only because I'm not here.
Because otherwise there's some complexity of getting the file.
He's handling my PCCs tomorrow. So he is already on the docket. He's already on my caseload. The PCCs tomorrow and the prelim's been set for June 23rd.
Okay, and do we, and I'm sorry I'm asking these questions.
Understandable.
Do we know if that individual has counsel yet?
They're conflicting.
Okay.
So there's another conflict counsel, which.
So this is my issue then. If we're going to have a hard date of the 23rd, I would suspect that counsel is going to come in and say, wait a minute, that's unfair for me. I need more time.
And that's fair. And that's fair. And that's somewhat what happened in this case also, that we had conflict counsel and we had to adjourn it to make sure that everybody had discovery.
The 23rd works for me, but I'm fearful that that's not going to go.
What about June 30th? Well, let's do this. I'd had a hard and fast rule of not adjourning, but I'd rather get everybody together. So, Mr. Berry, how does June 23rd work for your calendar?
It works for my schedule, and I think I know where the court's going, that we can have a backup date just in case.
Yes.
I don't know that the new co-defendant has been assigned an attorney.
Right, and so what I'm thinking is we regroup for June 23rd, have everybody here, and to see where we are with the third counsel and with the lawyer, with the understanding that we may need to adjourn that date in order so that third counsel has discovery and can zealously advocate for his client.
And I can appreciate that. I would ask that the prosecutor give me a courtesy notification
fair.
within a few days of that, so I'm not preparing for a prelim.
Right,
It's not
and
gonna
Mr. Barry, you'd also want the same courtesy call just to indicate whether on June 30th, we're having a prelim, or it looks like we'll be adjourning it because there's a counsel who doesn't have enough time to prepare.
The 23rd.
Yes, for the 23rd.
Yes.
All right.
All right.
That all works for me.
June 30th is the back.
All right, so let's do June 23rd for the preliminary examination. And then at this point in time, just keep this on your calendar, the June 30th date as a backup.
By grace of God, both those days actually work. That's right.
Even when I said it, I know I'm asking a lot, even when I said it. So the June 23rd is set for 8:30. And we're not setting it now, but think of that June 30th would be the same at 8:30?
Yes, sir.
All right, June 30th, 8:30. And that way we have a plan. And the plan is we've got a date and a backup date. I don't see this going past June 30th if for any reason that we have a prelim on that date and take testimony, okay? All right, is there anything else for the record in docket 23-0127 on Mr. Gaskin, or 23-1229 for Mr. Eskin?
I did hear you say how serious the charges were, but I didn't hear you on regarding my request for a bond.
The motion's denied at this
All
point. All right. And then, Mr. Barry, anything else on your file?
Officially for the record, so you can say mine's
All right.
denied as well, I guess.
Right, I'm denying all bond reductions based on the allegations that have been made at a probable cause level. And we will revisit this issue, and I'll be happy to revisit this issue on the 23rd or the 30th, whichever we choose.
Thank you, Your Honor.
Thank you.
Thank you. His copy or mine?
No, that's his copy.
Okay.
Didn't get enough. Another copy from Mr. Parker.
I should have.
We're all set.
So we should get it to in that file that Judge Buchanan's handling that we need conflict counsel appointed
All right,
ASAP.
yep, I'm all over it.
All right.
Come on.
All right, gentlemen, enjoy your weekend.
Thank you, you too, Your Honor.
Okay.
All right.
Hey.
Just since I got you don't have a Joanne Jackson. Do you? Okay. I don't know, just because there's no attorney on it yet, so I don't know if they're, doing. public
I have
defender
not
and the
heard.
Cub Scout
Well, what is that?
It's a PCC.
They're not conflicting her out, they just have an appointment. They're not conflicting that one, Jeff, they just have an appointment.
Oh, okay.
They're,
I don't know, when I don't have
they
attorney.
usually don't contact me except for something 10 or years or more.
Oh, okay.
Unless they really can't find somebody, and then they'll ask me. Thank you so much.
You're welcome.
And then they'll ask me. But
Yeah. Okay.
too thorough, they don't want to pay me.
I just figured.
Yep,
that-
I know that the third co-defendant are conflicting out, but Ms. Jackson, they were still working through the application.
Okay. Just so I knew kind of, I wasn't able to send an offer out to anybody, so.
Mr. Brody,
How you doing?
I got your stuff, but don't come through here. But I have something to discuss with you that I have not been able to review yet.
Head on down to Judge Buchanan's because Steve Crosby is doing a murder prelim down there.
Oh, what's murder?
I'm not entirely sure.
Buchanan?
Yeah, it's in Buchanan, but I'm not sure what exactly the case is.
As soon as I can